Okay, good morning and welcome to everyone. It is now 10 a.m. and I would like to formally open this specific issue hearing for the Vannin Offshore wind farm project. Before we introduce ourselves, I want to cover off a few housekeeping matters. Can I confirm that everyone can hear me in the room? Okay, thank you. And just attendees online, if you can't hear me, raise your hand. Some people have raised their hand. Okay, all right, okay. And then can I just confirm that live stream and recording have started? Yes. Okay, thank you. And then can I please request everyone to turn their devices, telephones and devices on to silent. Very quickly, toilets are through the double doors to my right. There are no planned fire drills during this event, so if you hear the alarm, please leave the building by the nearest fire exit and collect in the car park. Okay, moving on to panel introductions. I am Ms. Sahai. I have been appointed under Section 27 of the Marine Infrastructure Management Act 2016, or MEMA for short, to chair the panel of examiners for this application. Together we are known as the examining body. I confirm that I've made a conflict of interest declaration as part of my appointment, and I am a chartered member of the Royal Town Planning Institute, which means that I'm bound by their code of professional conduct. My declaration of interest and that of my panel colleagues were discussed at the preliminary meeting held yesterday on the 3rd of March. Anyone who wishes to do so may review the published recording for that event. A written note of the preliminary meeting is in preparation and will be published as soon as practicable. I'll now hand over to my fellow colleagues.
Morning, everybody. Can you all hear? Excellent. My name is Frances Fernandez, and I am a panel member appointed pursuant to Section 27 of MEMA. I confirm that I have also made a conflict of interest declaration as part of my appointment, and I am also a fellow of the RTPI, which means I am bound by the Code of Professional Conduct. Ms. Powell.
I'm Amanda Pownell. I'm a panel member appointed pursuant to Section 27 of MEMA. I can confirm that I've made a conflict of interest declaration as part of my appointment. I'm also a chartered town planner of the RTPI, which means I'm bound by the Code of Professional Conduct in the same manner as it does to other panel members and frames my conduct for this examination. I'll now hand over to Mr. Smith.
Thank you very much. My name is Ryn Smith, and I am a panel member also appointed pursuant to Section 27 of MEMA, and I confirm that I too made a conflict of interest declaration as part of my appointment. I am a chartered town planner and member of the RTPI, which means that I too am bound by the Code of Professional Conduct of that body in the same manner as it applies to the other panel members, and it frames my conduct in this examination too.
Also present today are Cabinet Office case team, notably Mr. Tom Randall, who provide procedural support throughout the examination process. Audiovisual service is provided by Energy Media Limited. Just a few words about how we intend to run the meeting today and the purpose of the meeting. Today's meeting is being undertaken in a hybrid way, meaning some of you are here in the room with us and some of you are joining us virtually using Microsoft Teams. Some of you have chosen to watch the live stream, and additionally, a recording of today's meeting will be made available on the MEMA website as soon as practicable after the meeting has finished. With this in mind, please ensure that you speak clearly into a microphone, stating your name and the organisation that you represent, if relevant, and each time before you speak. If you're not at a table with a microphone, then roving microphones are available, so please wait for one of those to be brought to you before you speak. Just a few words about personal information. When speaking, do think carefully about your personal information. If you feel a need to refer to something of a personal or confidential nature, please remember that anything you say will be included in the published recording. The Cabinet Office is administering the consenting process for applications made under MIMA, and in that regard, it will process personal data in accordance with the Data Protection Act 2018 and GDPR and LED Implementing Regulations 2018. Further information relating to data protection can be found in the Cabinet Office's privacy notice. A link to Cabinet Office privacy notice was provided in the Regulation 32 letter published on the 6th of February. I assume that everybody here today has familiarised themselves with this document. Please speak to Mr. Randall if you have any questions. Just a quick briefing on the purpose of the hearing today. Under Section 31 of MIMA and Regulations 31 and 34 of the Marine Infrastructure Regulations 2024, the examining body can hold specific issue hearings if we think it is necessary to ensure that the issue is properly examined and that principal stakeholders have an opportunity to make their case. The examining body notified parties of its intention to hold specific issue hearing 1, or SIH 1 for short, on the marine infrastructure consent and other strategic matters in its Regulation 32 letter issued on the 6th of February 2026. The agenda for SIH 1 was issued on Friday, the 20th of February 2026. It is a very full agenda. So we will keep timings under review, and we may decide to hold over some matters for written questions if we're running over. We will do that as we go. The examination under MIMA is an inquisitorial process, and it is for the examining body to lead the questioning in order to test the evidence before us. For the purpose of this hearing, I will not allow cross-questioning between parties. If parties consider that further points need to be explored, they should indicate this to the panel, and we will decide whether these matters should be pursued. While we will pursue some of your questions at the hearing today, some might be explored later through written responses from the applicant. Okay, turning to introductions, turning to all of you today. Welcome and thank you very much again for coming. Several parties have registered to speak today. It will help me to know who is present generally. So I'll do a roll call, essentially, and take very quick introductions. So if we can just start with the applicant, if you identify the person leading today, introduce yourself, and others on your front bench can introduce themselves as they decide to speak, if that's okay.
Yes, good morning. My name is Amy Sterling. I'm a Senior Associate Solicitor at Pin St Masons, and I'll be leading for the applicant today. Thank you.
Okay, if we could have the representative from Department of Infrastructure. I have Miss Emma Rowan.
Yes, thank you, ma'am. We actually have CMS online who are going to represent us, so I'll hand over, please, to Robert.
Sure.
Thank you.
You can turn your camera on. And microphone.
Yeah, good morning. I'm Robert Garden at Oswang, and I'm representing the Department of Infrastructure today.
Okay. Next, I've got three members from DEFA. Gavin Cleater, Ken Milne, and Richard Armitage.
Good morning. I will be leading from the DEFA team. I'm Ken Milne. I'm Director of Environment in DEFA.
Okay. I've got Mr. Martin Royal from Gulf Commissioners.
Yeah, Martin Royal, Gulf Commissioners. We did register to speak somewhat as a contingency. So,
Mr. Royal, can you just wait while the microphone's brought to you? Yeah.
Yeah, Martin Royal Golf Commissioners. We did register to speak somewhat as a contingency, but I very much suspect that we won't need to speak today because the matters are perhaps out of our remit, but we are here to take them in. Okay, thank you.
Thank you. Okay. Moving on to got Mr. Michael Gregg, representative for Berber Extension, Walney and Holdco, and I believe Mr. Gregg is present virtually.
Yes, good morning, Adam, Director with DLA Piper, as you say, representing Berber Extension Limited, Walney UK Offshore Wind Farms Limited, and Walney Extension Limited, and also Ørsted Schroders Greencoat Wads Holdco Limited in relation to their 50% shareholding in the West of Dublin Sands wind farm.
Thank you, Mr. Gregg. And then got Anthony McNamee from Scottish Power Renewables. Also present on Teams. If you'd like to turn your camera and microphone on, just so we know it's working. So we can see you've got a raised hand, but unfortunately I don't think we can hear you. Your microphone seems to be off. Okay, we'll come back to you, Mr. McNamee, once we've sorted out tech. I also have Flotation Energy, Mr. Oliver Wellesley Gardner.
Good morning, panel. My name's Oliver Gardner. I'm a consent manager for the Morecambe Offshore Wind Farm, representing the Morecambe Offshore Wind Farm today. I don't intend to speak necessarily, but I'm here, as others are, to listen, and if necessary, I'll join the discussions. Thank you.
And for the record, I know Mr. Gardner, as I have previously worked with him in a professional capacity, but not in relation to this application, the applicant more generally, or in relation to any interested party. I can confirm that no discussions concerning this application will take place outside the formal context of the examination.
Thank you. I do have a few other attendees. Is there anyone representing no offshore turbines for Isle of Man? I don't. Did I see a hand raised?
Hi, good morning. Gina O'Sullivan will be here, but she's currently had to take a family member to hospital, so expects to be here by about 10:30.
Okay, thank you. Sorry, could you repeat that name again?
Gina O'Sullivan, Georgina O'Sullivan.
Okay, thank you. And we've got BAE Systems, Rachel Ward. Ms. Ward, if you'd like to turn your microphone on and camera on.
Hi, hello, Rachel Ward here from BAE. I'm afraid my camera isn't working on Teams this morning. I'm here predominantly to listen and will only speak if necessary.
Thank you, Ms. Ward. I do also have Miss Amy Farger who's expressed an interest to participate today? She's not attending today. Understood. Okay. And Miss Anne Crane? Not attending today. Okay. Can I please confirm if there's anyone in attendance today who has land and rights within the order limits, besides the Department of Infrastructure?
My colleagues and I are representing Douglas City Council. We would have land and rights if Portskillion is used as a landfall location, but I understand from having watched the preliminary meeting yesterday, there is a non-material change to withdraw that. So we're not registered to speak currently.
You're not. Could you state your name, please, madam?
Dana Einon, Danaeynon.
Dana Einon. You're here regarding the change request. Is that what you said?
No, we're here for the specific issue hearing. But having witnessed the preliminary meeting yesterday, we understand there is a change request to drop Portskillion. Our interest would be in Portskillion.
Okay, understood. Excellent. Any other persons in attendance today who have land and rights within the order limits? I don't see any hands up in the room or on Teams. My next question was, any representatives from Manx Utilities Authority?
Morning, Stephen McGee, Interconnectors Manager for Manx Utilities. I'm attending today on behalf of Manx Utilities. There was a colleague as well of mine, the Estates and Wayleaves Manager, who was due to attend with me, but unfortunately due to personal circumstances he can't join us today.
Okay. Thank you very much. So it looks like we have a full house, and I have a fairly good overview of who everyone is and where everyone's sitting, so that's really helpful. Just confirming, any members of press attending? Not today. Okay. That concludes this item of the agenda. Unless there are any questions, I see no hands up. I am going to swiftly move on to the first substantive item on this agenda. Right. Before we move into agenda item 3, I just want to explain the logic of how items 3 and 4 fit together. Agenda item 3 is about the whole project. It's about understanding how the 3 separate projects that make up the whole project sit with each other. And by the 3 projects, I mean 1, the generation project that's before us, the East Irish Sea Transmission Project, and number 3, the Terrestrial Electrical Connection Cable, or the TECC, the onshore substation, and the operations and maintenance facilities. So these 3 components. Now, I want to do that for one reason, and that is to make sure that adverse effects are being properly accounted for in the environmental statement, and that what needs to be assessed in this examination is actually covered. And by that token, what needs to be authorised or controlled by the draft MIC is authorised or controlled. Once we have that clarity, we will move into agenda item 4. Agenda item 4 is about the project within the order limits. In other words, what this draft marine infrastructure consent actually authorises. So the progression is deliberate. First, we understand the whole project and the assumptions the assessment relies on, and then we focus on the order limits scheme and test whether what is authorised has been assessed. So with that in mind, I'm going to take agenda items 3A and 3B together. As set out in figure 2 of chapter 3, which is examination library reference APP-041, there are a number of components which form part of the whole project for the purposes of the EIA, and they are subject to different consents outside of the MIC application before us. So, for example, the TEC, the onshore substation, and the operation and maintenance basin facilities are proposed to be consented under TCPA in the Isle of Man, and the offshore export cable is to be consented under the East Irish Sea Transmission DCO application in England. Now, in reviewing the description of these projects, it's not immediately clear to us what parameters have been used as part of the assessment in the EIA. So, for example, there's no plan or indication of the indicative route provided for the TEC. There's no plan for the onshore substation, whilst it's stated that this will be in proximity to the existing substation at Middle River. There's no further details has been provided. There are maximum parameters for the substation, but these are not secured. There is no plan for the onshore operation and maintenance facilities, and whilst it's stated it'll be in proximity to Douglas Harbour, there's no further detail. Once again, there are maximum parameters for this in Table 6. My understanding is that these are not secured. Now, the East Irish Transmission Project, this project, I believe, is at a relatively early stage, because I note that the EIA states that the scoping report is anticipated to be submitted to the government in Q2 of 2025. Now, in this context is where I have asked the applicant to give us a 10-minute presentation to explain to us, with the use of plans and visual aids, what are the components of the whole project that fall outside of the draft infrastructure, marine infrastructure consent, and that have been assessed within the ES, and what parameters, including location, scale, footprint, construction assumptions, and operation assumptions, were relied upon. And agenda item 3B, what spatial and design assumptions, example, location, scale, footprint, and again, construction and operational assumptions were used for assessment purposes of the terrestrial, the TEC, the onshore substation, and the operation and maintenance facilities, and the East Irish Sea Transmission Project. So I'll hand over to the applicant.
Yes, thank you, Madam. Amy Sterling on behalf of the applicant. I will pass you in just a moment to Dr. Julian Carolan of Ørsted, who can walk you through the approach to environmental impact assessment of the various 4 components of the whole project. Before I do that, I think it would be useful, just in response to your helpful clarity and the reasoning behind the agenda items and the questions, to sort of set the scene, as it were. The planning case for the development, the delivery of the island connection is an important potential benefit that the scheme could provide to the island. However, it does require further technical and regulatory work in order to identify the location and the technical deliverability of that connection. This is recognised in Manx Utilities' consultation response, and the applicant is working closely with Manx Utilities and the Isle of Man government in relation to this. Conversely, the primary route to market and the primary offtake solution for the development is through the East Irish Sea Transmission Project to the UK. The primary purpose is to export the electricity to the UK. There is more certainty in relation to the East Irish Sea Transmission Project. Again, Dr. Carolan can provide you more details. However, a Section 35 direction has been obtained from the Secretary of State. The EIST will be consented via Development Consent Order. It will benefit from the full policy support of the national policy statements with an established substantial need. A scoping report has been prepared and submitted. A scoping opinion has been received, and the applicant is working towards submission of that DCO application. The parameters, therefore, of the EIST, which is functionally dependent on the generation assets, are more defined, and that is reflected in the approach of the applicant to its cumulative effects assessment. In contrast, the island connection is more under development, and that also is the case for the O&M base. The location, the technical specifications of those are less known and less developed. Again, this has been reflected in the environmental impact assessment. So I'll pass to Dr. Caroline now to walk you through it, but I just think it's helpful to set that scene. Thank you.
Good morning, Dr. Jill.
Sorry, can I just confirm that this is the presentation before us? Or are you just going to use that diagram?
I'm going to use that and many others.
Okay, okay.
Yeah. Dr. Julian Kjorlan, Consent Project Manager at Mooir Vannin on behalf of the applicant. I've got a few slides just to explain the various constituent parts of the whole project. And we've, on the slide behind you, we have the whole project infographic, which incorporates all parts of the Mooir Vannin offshore wind farm project.
You're coming across quite softly to us. Are you able to just up the microphone? Or? Yeah, if you could move the microphone a bit closer.
It's quite rare that I get accused of coming across softly. I'll note that. My mum will be happy. So we've got the whole project infographic, which incorporates all parts of the Mooir Vannin offshore wind farm project, which includes the Mooir Vannin generation project, highlighted in blue, the East Irish Sea transmission project, which is the export of the electricity to the UK grid in purple, and then the two constituent parts on the Isle of Man, which are the operation and maintenance base and the TAC, the terrestrial export cable corridor and the onshore substation. So there are 4 components, not 3 as previously alluded to in your introduction. The next slide shows the spatial arrangement of those. So this shows the electrical infrastructure study area, or the electrical infrastructure search area. And this is both of these figures are taken from the scoping report, and these ones specifically are taken from the site selection consideration of alternatives, and they are presented in document APP 004. And it shows the spatial arrangement of those constituent parts of the Mooir Vannin offshore wind farm. The figure in the right shows the agreement for lease area in red, and then the early stage planning for the East Irish Sea transmission, which at that time could have made grid connection in either the UK or in the Republic of Ireland. And then those parts in the figure on the left, which show the island link and the transmission funnel to the UK for the East Irish Sea transmission. So a little bit more detail of zooming in on the array area. So that incorporates the spatial elements of the East Irish Sea transmission project. I think it's really important to note that the figure in the bottom left that shows the search area for the terrestrial connection on the onshore substation, this was early in the development, and that incorporated Middle River substation and the terrestrial export cable corridors to get to there. That was before MEMA was updated, and then MEMA was limited to 250 metres landward of mean high water, and that then restricted the applicant from taking on any consent for that part of the project within this MEMA consent, as well as the legislative issues that Ms. Sterling alluded to previously. The next slide. So in terms of the technical parameters for each of the respective components, these are set out in table. This is for the terrestrial export cable corridor and the onshore substation. So the technical parameters are set out in table 4 of the project description, which is provided at APP 041. And that sets out the number of cables, the trenches, how the cables will be installed, and then the onshore substation design parameters. All of the components have been set out so that the reader can familiarise themselves with all aspects of the Mooir Vannin offshore wind farm project. The spatial component then is set out in the images on the right hand side. On the next slide, please, Tom. So this is table 7 taken from the project description. And this sets out the technical parameters for the operation and maintenance facility. The operation and maintenance facility is a requirement of our AFL, and the site selection for that process is confidential at the moment. We're working with the Isle of Man government and DOI Harbours to identify the correct location for that facility, at which point then we would bring forth the environmental impact assessment and associated planning application for that part of the Vannin offshore wind farm project. It basically has an O&M base, a quayside, and some storage facility, which is all set out. Unfortunately, due to the nature of that project, we're not able to confirm the spatial component of it or the temporal aspects of it, so it's not possible to conclude a full and formal EIA at present. The next slide. So this one we have more certainty around is the East Irish Sea Transmission Project. As Ms Sterling confirmed, we have a Section 35 direction and a scoping opinion from the Secretary of State. And the infographic on the right hand side confirms the export cable corridor from the southeast corner. So the cables exit from the Mooir Vannin array at the southeast corner and then make their way across to the English coast and onwards to grid connection at Penwortham. And we have a formal grid connection offer from National Grid. And the spatial components, the temporal components, all of the other technical parameters are set out in table 8 of the project description. And the assessment for that has been carried out within the respective receptor chapters of the EIA. The key component for that in terms of the assessment, which we will cover under agenda item 4D for the cumulative effects assessment, relates to what is called within the Mooir Vannin application, it's called the transmission asset funnel. As the East Irish Sea Transmission Project is essentially buried cables within the seabed, the main impacts that could interact cumulatively and in combination with the Mooir Vannin Generation Project relate to those seabed activities within 12 kilometres of the Mooir Vannin Generation Project. And that's used as that's generated from a tidal excursion from which all impacts of sediment and hydrodynamic process could potentially interact cumulatively and in combination. That concludes the introduction to the whole project, and I'm happy to take any questions in relation to it.
Thank you very much. So just in terms of the assumptions, a lot of those assumptions that you presented, the parameters, apologies, that you presented to us, and I'm going to come to that question a little bit later on in 3C and 3D. What I would like to understand is, actually, I think I'm going to wait, and I will come to that in 3C. I will probably hand over to my colleagues to ask their questions first. Ms. Pownell, I believe you've got a question, and then Mr. Smith.
Yes, thank you, Chair. So, figure 3.2, I think it's APP 003 that you've referred to, the first figure. So you said there's 4 project stages. This has got 5. And can I just clarify? So the onshore substation is shaded in the same colour as the proposed development. So was the original plan to include the onshore substation as part of the development application, and then that was subsequently excluded? That's my first question. And the second question is, so the onshore substation and the scope of the onshore activities, excluding the OECC, are less technically, there's less technical information available, the spec's less, it's less known, it's less developed, and there's no spatial component. So it is in figure 3.2, it is a component of the scheme. So the second question is there a programme for developing these elements of this substation and the operation and maintenance base available, so that we can actually get some context around
what this actually is and when we'll have the information and oversight as to when it's going to happen. So it's 2 questions.
The first question in relation to the onshore substation forming part of the original project. Our intent at the beginning was we thought that MEMA was going to be brought forward to be the same as a development consent order, and it would incorporate the onshore parts, so that with any vanilla type wind farm we would have the generation asset, transmission asset and the connection. At that point the onshore part of MEMA hadn't been defined, so we originally thought it was within scope, the onshore substation. MEMA then was defined as being limited at 250 metres seaward, so it wasn't possible to incorporate that. Through then the early development activities with Manx Utilities, then we've come to an understanding that we can't bring forth the island link in isolation by ourselves, and ultimately Manx Utilities and their role on the Isle of Man and dictates basically our engagement with them and to a large degree how that project is brought forward. So initially it was part of the scheme, but then it broke away for a legislative perspective.
Ms. Fernandez, did you want to come in at this point?
Yes, thank you very much. Thank you for that brief overview. In relation to the potential location of the grid connection and substation, what is preventing the applicant and Manx Utilities on confirming the location of the proposed onshore substation until after the conclusion of the MIC process? If I may put that to the applicant, and then I would also be interested to hear from Manx Utilities on this point.
Yeah, our early discussions with Manx Utilities indicate that the grid connection could most likely be Middle River, Pulrose. So we know that where the location would be. Is the selection of the appropriate landfall on the routing is basically something that isn't in sole control of the applicant, and that will be done in consultation with Manx Utilities. The exact nature of that grid connection, the capacity of the island link and the onward connection works needs to be developed in consultation with Manx Utilities. So until that agreement is in place, the applicant isn't in a position to conclude a full and formal EIA on that work.
Amy Sterling, on behalf of the applicant, I also just want to remind the panel of our commitment yesterday to providing a statement of common ground with Manx Utilities at deadline 1, and I feel like this is probably a helpful topic that we can cover within that statement of common ground.
Thank you, and indeed if I may invite Manx Utilities to respond on this point, that would be helpful. Thank you.
Stephen McGee,
would you like to come to the table?
Yeah.
Thank you.
Thank you. Stephen McGee, Interconnectors Manager for Manx Utilities. Yeah, just to summarise, just to reaffirm, the marine infrastructure consent only brings the offshore cable ashore, as mentioned, 250 metres inshore. From that point inland, Manx Utilities will deliver the terrestrial cable connection through a separate planning process. We have already carried out high-level work to understand the range of feasible grid connection options, including potential points around Middle River and Pulrose Power Station. Several possible inland cable corridor options have been identified for future evaluation, but no final decision has been made as yet. The eventual connection point will depend on detailed technical assessments still to come, including network capacity, voltage performance, protection coordination and overall system stability. So while the connection will ultimately be made into MU's transmission system, the exact location is still open and will be confirmed through MU's separate engineering consent and process.
May I just do one follow-up on this? What is preventing progress being made now on this? Why are we waiting for the outcome of the MIC process? I'm not understanding the reasoning, and I'd be interested again to hear from Manx Utilities and from the applicant.
Okay. If I
you mind if I go first, Julian? So on that, there's still some technical discussions around the extent of the cable connection to the island, specifically around the type of connection in relation to its voltage and capacity. That makes a big difference to where actually we can make that connection, a suitable connection on the transmission system. So that detail has still not actually been agreed, and that will form part of an ongoing commitment by Manx Utilities and the applicant. As mentioned previously, we are working on that with the Statement of Common Ground as well, to try to give confidence that that process is in place.
So and the applicant, please.
So is there this is a big project, an immense undertaking, onshore, offshore. Is there a programme for this onshore spec, solution, activity, application, submission? Can we get some clarity on it and when it's likely to happen, this application?
Yeah, we do have an outline programme.
Okay.
Obviously, it is very dependent on the outcome of the MIC process itself to be able to take it through into the next sort of stage of its feasibility and then into its obviously full technical design. We can give an indication of what that programme may look like in a written form after this.
Could you provide it in a written form, but
Yes.
also explain with clarity how it relies on the success or not of the MEMA application? That would be very helpful.
Yep, understood.
Quite as much detail as you can provide. But also, just a clarity point also, could you update figure 3.2 so that it's very clear what actually is in the application on that figure? That would be very helpful, thanks.
Sorry, and if I may go back to the applicant in response to my question.
Sorry,
earlier.
if you could just clarify what needs to be updated in 3.2, because I'm not really sure what needs to be updated.
So figure 3.2 shows the onshore substation as part of the proposed development.
Which figure 3.2?
Figure 3.2 in APP 033. It was the first figure that you showed up in your presentation?
From the scoping report.
I'm sorry?
It's from the scoping report.
Okay, could you present it then to the application, to the panel as a new figure for deadline 1, updated?
Sorry, but it's a historical document.
Okay.
Dr. Carolyn, is there an updated, there is indeed an updated project description. Would you please give us the reference for that, perhaps after the coffee break, so that we know where that is in the documentation? Thank you. And then if I may just take us back to the question, thank you very much from yourself, Mr. McGee. It was in response to the question of progress and why. I understand from Manx Utilities that the export cable corridor is still in discussion, and that has some bearing on the onshore cable corridor. Dr. Carolyn, I would be interested to understand from the applicant's point of view how the conversation is going with Manx Utilities and likely progress and timescale, please.
Yeah, Dr. Julian Carroll on behalf of the applicant. We have been in consultation with Manx Utilities now for a considerable period of time. It's not a really straightforward option on just defining what that transmission asset is going to look like. There's significant work that needs to be done on the capacity on the output from the wind farm. So we've been looking to bring on the island link. So for the output in the region of up to 100 megawatts, the exact megawatt output needs to be determined in consultation with Manx Utilities, and they're still doing some internal technical work on that. Once that is defined, then we can determine whether it's one cable, whether it's two cables. We have a maximum design scenario within our island link of 2 technical export cables. It may be that the Manx Utilities only require 60 megawatts and not up to 100 megawatts, so that would impact the project. So it would be either 1 or 2. When we get that confirmation, then we can begin to design that in, and then we can select the most appropriate landfall site and the most appropriate corridor. Anything ahead of that would just be speculative and wouldn't be possible to conclude.
Amy Sterling on behalf of the applicant. If I can just jump in here, I think, again, just to go back to some of the comments, and I tried to set the scene earlier. I think Ms. Penrose, you suggested that the onshore elements within the Isle of Man and the project are, a substantial project. To be very clear, the onshore elements and the island connection is a relatively small part of the whole project. As Dr. Caroline said, it's potentially a connection of between 60 to 100 megawatts of a 1.4 gigawatt project. The vast majority of this project is the array and the East Irish Sea transmission project. I think I would also like to just sort of manage expectations. There is, of course, the question of how much power this project can deliver to the island. There's also the question of how much power the island can accommodate within its network system. Manx Utilities have a very complex job of balancing the network, ensuring it is robust and the necessary upgrades are in place. That takes time, and I would like to manage your expectations that I don't expect that there will be a defined route for the onshore terrestrial connection within the timescales of this examination, and neither do we consider that it is necessary, given it is a relatively small part and not actually integral to the entirety of the project.
Understood, but my point is that within the context of the Isle of Man and infrastructure development, it is substantial. Because the island itself.
Possibly, it's potentially laying one underground cable and one substation.
Okay, thank you.
Thanks.
We've got a few follow-up questions on this point. So I'm going to hand back to Ms. Fernandez very quickly and then to Mr. Smith. And then we will carry on with a few other follow-up points.
Thank you very much. I think it's quite important as we start these hearings that we look forward positively to how we can make progress and understand the questions that the panel is answering, and doing that in an open-minded way. So probably managing expectations phraseology is not that helpful. What we're trying to do is understand the application, understand the potential matters that will affect all those involved in the application. And so, again, the characterisation as this is only a small part of the project may be so if we're talking in purely electrical terms, but remembering that this is a significant project for the Isle of Man that we are considering, and just be mindful about the different impacts and effects that they may have on the communities and all those involved in the project, please.
Amy Sterling, on behalf of the applicant, yes, of course, I in no way mean to, offend the extent of the infrastructure, but I do think it is really important that the panel understands the scope of the project that we are applying for, and indeed the nature of the onshore works that may be required, which is, as I've said, the laying of an underground cable, possibly two, and an onshore substation. That is different from the offshore infrastructure, which of course has other impacts on the Isle of Man, such as seascape, landscape, visual impact assessment that I'm sure we'll come to. But thank you.
I'm going to get Mr. Smith here, and then hand over to Ms. Pownell for a very quick clarification questions. I do want to open up the discussion to other members as well to seek some views, and then I do have a couple of final points from me before we move on to 3C and 3D. Mr. Smith, over to you.
Thank you very much, Ms. Sahai. What I just wanted to do was to step back from the specifics of the mechanism whereby Manx Utilities might or might not make use of a landfall, and just try and test the proposition that the offshore corridors to the landfall locations are A, broadly in the right place, B, broadly capable of a meaningful implementation of a connection to the Isle of Man at some point, should that be resolved, and C, that to the extent that within the capability, the 250 metre limit issue and the capability of MEMA, you currently have within the red line boundary and have done sufficient diligence and scoping to form a view that you have land that is broadly appropriate for the development of landfall facilities, broadly, for example, accessible for the purposes of construction or any special techniques such as horizontal directional drilling or cliff drilling that you might need to make a landfall. Because certainly the general approach in such circumstances in previous consents in the UK, where there has been uncertainty, for very often good reasons, is essentially then to look at the parameters of risk and look at the degree to which what is being proposed is in broad terms likely to be capable of being brought forward, or whether in fact there are concerns about whether it's actually even in the right place or even technically feasible in the landfall location. So a brief response on those broad points, please.
Dr. Julian Kjorn on behalf of the applicant. As I said previously, we've been working extensively with Manx Utilities now for a number of years on the landfall, the cable routes, and all of the technical parameters for the project in relation to that technical or to the terrestrial export cable corridor on the onshore substation and what that could look like. So we're confident that the landfalls as identified at the point of application were sufficient and would allow us to deliver the island link. And we've since refined that in light of the comments that we've received in the consultation responses and in consultation with Manx Utilities, and we've sought to refine the project down to minimise the optionality within the project as we move towards greater technical certainty with Manx Utilities, and hence reducing the project down to Groudle to give us those 2 sites that remain. So we're confident that we can get there, and the project has been designed accordingly, both within the offshore, hence the number of offshore substations that we have to allow for that connection, for that island link in whatever configuration it could be, and that spatially that we have enough room for 2 export cables and that they're appropriately sited, avoiding all environmentally sensitive features en route to landfall. And from there we're happy that we can work with Manx Utilities to deliver this. Our state has significant experience in the UK. We have 12 operational wind farms. We're the industry leader in this, so we feel confident that we have a strong track record and we can sit here with confidence and say, yeah, that we can bring this forward. We just need to basically work on the technical aspects with Manx Utilities, and are confident we can do that.
Ms. Pownell, I believe you had a clarification follow-up question.
Yes, I'm sorry, I might have given the wrong figure reference. Yeah. You said the figure was historic. I do apologise. It's figure 2 in the project description in the main ES. That's the figure that I actually would be grateful if you could update. Would that be all right?
We can update. And what exactly is the update?
To show the proposed development.
The proposed development in blue?
Yes. I can see you've taken on that in the next document. Thank you. I appreciate that.
Thank you.
Thank you. I've got the clarity I needed.
Okay.
Can we just take a couple of minutes to identify the actions that we've got from both of these agenda items? So there is an updated figure. Ms. Pownell, you will clarify that. We did request a programme for how some of these projects coming forward and how they will sit together. And I think if I could just add there, especially because of some of the representation that we've heard from Mr. McGee and from you, Ms. Sterling, what are the triggers for, at what point, what aspect of the project gets triggered, in particular the terrestrial components on this island, and at what point do you decide that the primary, as you've set out, the primary aim of the project is to export the energy to the UK? At what point do you make that decision? Whether that is something that's ever going to be within this examination, or whether there will be any testing of that, aspect in this examination. So I think that programme with with that justification sitting alongside it would be really helpful. And I'm just going to quickly go through my notes. Did you have any actions that I've not read out right now?
Amy Sterling on behalf of the applicant, no.
Yeah, the statement of common ground is a given, so I'm not going to put that in actions. Okay, good. I do want to turn to parties in the room, particularly parties to my right. Is there anything that's come up today that you wish to comment on, that's come as a surprise? Is there full understanding of it? I've got GARF Commissioners, Mr. Martin Royal, your hand up. Would you like to come up to the table, please?
Yeah, I'm surprised we need to speak today. Martin Royal Garth Commissioners, the commissioners like yourselves are looking for a very positive process, but actually just sitting back there I picked up some disquiet amongst yourselves, what we've just heard, which in many ways is very professional and very clear and so on. And please remember that we, the commissioners, are small people in this. We're coming new to all these things, but there's something in what we just heard that presents as very vague. And I think more reassurance is needed about the whole project. I think what we need is a clearer idea of what's possible and practical across the whole project, particularly in terms of what's happening or going to happen on shore. And I think you people need to, obviously, I'm telling you something you already know, you need to know that before you can decide on the offshore elements. I mean, a colleague has just reminded me of the gunning principles, and which set out how these things should be presented and so on. And it doesn't, what we have heard doesn't quite read in those terms, or certainly not the clarity that the gunning principles seem to seek. But basically it is this, that the examining board, you know, we recognise you must be in a position to assess the wider environmental impacts beyond what MEMA is setting, because you've got to ensure that the whole thing is deliverable. We accept that some flexibility is needed in the approval, but there must be a balance with some certainties at least, and we would like to see that clarified sooner rather than later. I mean, a question perhaps for another time is, have landowners been considered in terms of the landfall at the Isle of Man, and has anybody been approached? Do we know if this is deliverable? And as I say, we sympathise with your need and desire to set that balance between flexibility and the final certainty of what eventually is approved, if it's approved. Thank you.
Any responses to that, Ms. Sterling?
Yes. Yes, Amy Sterling on behalf of the applicant. I think we're into agenda item C now, which refers to the various bits of case law. We can, of course, provide our legal position in writing. I would disagree with some of those statements made. I disagree that the panel needs certainty on the delivery of the onshore element of the island connection in order to consent the array. As I've said, the applicant's primary functional dependent grid connection is the East Irish Sea Transmission Project. That is required to deliver the generating capacity, not the island link. Also, planning law doesn't require certainty. It requires a reasonable prospect of delivery and no obvious impediment to delivery. The applicant's position is that there is a clear consenting process and indeed opportunities to acquire the land. We'll come on to that in later agenda items, such that there is a reasonable prospect of delivery of the island connection and that there is no obvious impediment to the island connection being delivered. That is our position. But nevertheless, as I've stated several times now, the primary offtake solution for the wind farm is via the East Irish Sea Transmission Project.
Ms. Sterling, whose objective is that? Is that yours, or is that the Isle of Man government's objective? Because what I'm slightly struggling to understand, and I wasn't going to touch on that in today's agenda, but perhaps a quick look into that, and because we will get into that in greater detail in questions, is that in terms of actually understanding when we are looking at the project and what benefit it brings, what is that assessment before the examining body? And when you say that the primary objective of this, is that for Mooir, Vannin Offshore Wind Farm Limited, or is that for the Isle of Man government?
Amy Sterling, on behalf of the applicant, it is both. As I it is set in our planning statements, planning support statement. We will be updating it. I won't spend lots of time quoting policy at you, but if I may, I will quote some of that policy to you. So from as early as 2012, in the Manx Marine Environmental Assessment, which the Isle of Man government prepared and consulted on, the Isle of Man included a section on offshore wind. It said that offshore wind development in the Isle of Man territorial waters would be a cost-effective approach to supply renewable energy to the UK electricity market and to assist the UK government to meet its targets. Then in 2013, the Isle of Man launched its Vision 2020, where it identified the island as a central location for generation of electricity to the UK. Also in 2013, the Council of Ministers prepared a report on energy, and it said the government will explore opportunities to develop in offshore energy production in the territorial seas for export to neighbouring jurisdictions. Then again later, development of the offshore wind farms would generate revenue to government from the leasing of the seabed and create new jobs providing operation and maintenance bases. I could go on. There's been a clear direction of policy for around 14 years now that the delivery of an offshore wind farm within Isle of Man territorial waters with an export to neighbouring jurisdictions, specifically the UK, is the policy of the Isle of Man government. The applicant is responding to that policy with this application through a process which again has been set up by the Isle of Man government to facilitate the development of that offshore wind project. The connection to the Isle of Man is an additional benefit that the applicant may bring forward if it is possible to do so, and indeed Manx Utilities is able to accommodate the connection within the island's grid system.
Thank you, Ms. Sterling. There are a couple of actions there, but I'll come to you with those actions in a second. Can I just invite DEFA, Mr. Milne? Are you speaking for DEFA, or did you say that there was somebody else representing?
Sorry, Ken Milne from DEFA. I'm speaking for DEFA.
You're speaking. Did you have a response to that in terms of the progression and the repeated policy that Ms. Sterling has quoted, stating that the primary aim is to export energy to the UK?
When this project started and commenced the licensing round, it was for the export of power to the UK. It was the predominant factor.
Any further points, Mr. Milne? Do you support or?
I don't think so at this point.
No? Okay. All right. I just want to open it up to other parties on my right, and if you had anything to say to that.
Ian Brooks for Department of Infrastructure. I don't think we have anything to add to that.
Thank you, Mr. Brooks.
Mr. Milne, would you provide us the evidence of where that primary purpose is set out in Deadline 1? Whilst the applicant may refer to it, it would be quite helpful for you to confirm that as well.
Yes, certainly we can come back with a written response for that, those documents that were quoted, yep.
Yes,
They're
thank you very much.
available online. Thank
you. Lovely, thank you.
Amy Selling on behalf of the applicant, just to confirm the majority of what I quoted there is already before the examination in document APP 065, our planning support statement.
Yep.
We will of course be updating our planning support statement to provide more information and further background and really make clear what the planning case is for this scheme, because I do appreciate it may be lost, I think, in the volume essentially of documents that we've provided.
No, Ms. Sterling, it's not lost, but I think what will be helpful is if it's perhaps pulled together in the statement of common ground, and it shows some agreement, because we've requested a statement of common ground with DEFA. So that policy basis, if that can be set out and agreed in the statement of common ground, I think that would clarify matters for us quite significantly.
And the deadline?
Deadline 1, all statements of common ground are coming at deadline 1, yeah.
And the response from DEFA at deadline 1?
Okay, we've got a member of the public wanting to speak.
Good morning, thank you very much. Ian Strafford, resident of the Isle of Man. Whilst I listen with interest with respect to the policies that have been stated, I'm aware there are other policies of the Isle of Man government as well with respect to landscape, with respect to character assessment, with respect to the Climate Change Act of 2021 in terms of achieving net zero and so on. And all I would request is that whilst the policies have been quoted provide one side of a picture, there are other policies of the government of the Isle of Man that need to be balanced against those to ensure that everything is on the table and not just the policies that have been quoted seemingly in support. Thank you.
Mr. Stafford, we've recognised that, and as you're aware that we've requested local authorities to submit what's called a local authority effect statement. One of the key questions in the local authority effect statements are what are the local policies that are relevant and should be tested and should be before the examining authority. So we are seeking that balance in that regard.
And I appreciate that. And those are local authority effect statements, which obviously will give us specific issues with respect to the specific areas of the local authorities. I'm talking about policies that are at government level and that need to be taken into account in addition, so that we have a balanced government position against all government policies, not just those with respect to export of electricity of the end use of the territorial seas. Thank you.
Mr. Stafford, because
it's
this
Mr.
is
Strafford.
Strafford, my apologies. Mr. Strafford, because this is not an agenda item today, I'm not going to spend any further time, but that's a very interesting point. So I'm going to note that as an action against your name for deadline 1 to provide any national level policies that you believe counterbalance, so to speak, the energy supply policies that the applicant has just stated.
Okay, I'll take on that government role for you. Thank you very much.
Amy Sterling on behalf of the applicant, and without wishing to refer to the planning support statement throughout the entirety of my submissions, to confirm we will be updating that again to make further submissions, for example, in relation to the environmental policies within the Island Plan, which are the subject of the agenda tomorrow, which protect and conserve the environment, as to how we meet the planning balance, as it were. The Climate Change Act is already referred to in the planning support statement, but we as well will take the action to ensure that the full range of government policy is reflected within the planning support statement, and the adverse and beneficial effects of the project are appropriately weighed, and it will not be just one-sided within that planning support statement. So then we will submit that for deadline 1. Good. And in which case others will have the opportunity to, of course, review and comment on that, which might be helpful.
Okay. Ms. Sterling, that's helpful. And we'll just clarify that in our hearing action as well. But although you have confirmed you're submitting it anyway. Just one point on how we're running today. Just wait for me to come to you, if that's okay. And then we will invite you at all points. Bear with me while I just see if my colleagues have any further comments. What do I do about that?
Just while my colleagues are discussing something, Mr. Strafford, also just to be aware, and for everybody in the room, we will be issuing first written questions on or about the 10th of March, and that will have questions across many, many different areas. So these specific issue hearings, as indeed the name infers, are on specific issues. So whilst it might look like we're only looking at a small vignette of a wider application, it is just that. It's not that we're ignoring everything else, but we are very much focusing on specific bits and bobs, but our written questions will be far more comprehensive. So anticipate those at the beginning of 10th of March or thereabouts.
And if I may briefly, Ryn Smith, member of the examining body, just follow up on that to paint a very brief picture of the process that we will then take as we move towards making a recommendation, which that we have to consider all applicable, all relevant and operable legal duties and policies from at whatever tier of government they arise, and then we have to assemble our consideration of the performance of the project against those policies through a process that we routinely refer to as a planning balance. And it won't be until we're at the very end of the examination that we have the full picture before us that will enable us to do that exercise. So never leave one of these events thinking that there was only a partial consideration, or only one policy or three policies referred to, or didn't refer to government or didn't refer to local authorities. In the round, across the full period of the examination, rest assured, a full review of all applicable policies will occur.
Thank you, Mr. Smith. Unless there are any further points and any responses from the applicant, I'm going to move on to agenda item 3C. Again, I am just going to step back from the question here in the first instance. Regulation 6 of the Marine Infrastructure Regulation, or MIR for short, provides that the provisions of MEMA extend to such works where the infrastructure in question passes through the mean low water mark to any point from that mark to a point 250 metres landward of the mean high water. Works which fall outside this boundary would therefore fall outside the scope of MEMA and would need to be consented via a different regime, which is Manx TCPA. But in our view, this geographical limit does not apply to the consideration of the adverse effects of the proposed development. So EIA 2017 regulation provides that the EIA must identify, describe and assess in an appropriate manner, in light of each individual case, the direct and indirect significant effects of the proposed development. So in our view, this is not to be limited to the effects within the geographical limits of MEMA, and indeed indirect effects which go beyond the boundary of the proximate project itself will fall within the scope of the EIA. So whether any element of the whole project assessed in the ES could ultimately be consented in a material. So our question is, could be consented in a materially different way through the Town and Country TCPA or the UK DCO regime, and the effect of that on the robustness of the ES assessment underpinning the proposed development secured through the draft marine infrastructure consent. So if I could just get the applicant's views on that.
Amy Sterling on behalf of the applicant. The applicant considers it has identified a reasonable maximum design scenario. As Dr. Caroline referred to, this is based on the applicant's substantial experience in not only consenting but constructing and operating many offshore wind farms, the global leader in offshore wind development. The applicant therefore considers it is unlikely that the elements which comprise the East Irish Sea Transmission Project, which have already been scoped, and the onshore connection works are materially different from the maximum design scenario that has been included and been assessed. So therefore the applicant considers it has taken a robust and proportionate approach to the assessment in accordance with policy and indeed case law, which I'm sure we can come on to inform the examining body's assessment of the application at this point in time.
And I'm not talking about cumulative effects here, but is it your view that the potential to consider adverse effects within this application and therefore in this examination, where the effects are not caused by the proposed development, the bit in blue in that diagram, need to be considered in this examination? And if so, what is that scope?
Amy Sterling on behalf of the applicant. Yes, we agree, which is the approach the applicant has taken to assessing the whole project within its environmental impact assessment. The applicant has not considered only the proposed development, it has considered the whole project. However, the vehicle that it has used is through the cumulative effects assessment by assessing, for example, and ascribing the East Irish Sea Transmission Project as Tier 1 status. This is an acceptable approach. It has been trialled in multiple consented offshore wind projects in the UK, where the grid connection projects are proceeding separately and behind schedule from the generation project.
I am about to move on to agenda item 3D, which is the point that we stopped here, cumulative effects. But I just wanted, open the question up to the floor if anybody had any comments or concerns, and whether, particularly to the parties to my right, and whether they are, generally content that that approach is robust, as set out by the applicant. Okay, I don't have any questions, so I'm going to move on to agenda item 3D. Oh, my apologies. Mr. Robert Garden.
Thank you, Robert Garden, on behalf of the Department of Infrastructure. I think we're content with the approach taken. Obviously, there have been some specific comments that have been made in relation to the environmental assessment by the department, but in terms of that approach to assessment, we are generally content.
Thank you. Okay. So moving on to the cumulative effects assessment then. We've read the cumulative effects assessment methodology, which is APP-073, and also seen that the ES chapters provide a cumulative assessment with other projects based on that methodology. But however, what's not clear is how the elements or the three parts have been considered in the assessment and what assumptions and locations you have used. And we will come on to that in agenda item 4. So I am ever so slightly asking this question back to front. But in relation to the reliance on other consents, whether it can be assumed that those will operate. Actually, I'm going to do this in two parts. So the second part is what I'm asking now. So in relation to reliance to other consents, it can be assumed that regimes will operate effectively. Our question is whether the assessment provided at this stage is robust and based on the best available data.
Amy Sterling on behalf of the applicant. I believe we've covered much of this, I think, in our discussion up until now. Our position is yes. I can pass to Mr. Carolan if you want to walk through the cumulative effects assessment, the tiering, and actually how the assessment has been carried out to assess the impacts and present the impacts of the whole project to the extent it is possible at this stage. However, our position is that we have taken a robust and proportionate approach to the assessment based on the available information, which, as we've discussed in submissions up until now, varies depending on which element of the whole project you're referring to.
I think the question more is to satisfy us how you feel that assessment has been meaningful, given that a lot of the assumptions about locations are or rather there's still a lot of uncertainty about locations of where certain components of the project will be placed, not just within the proposed development within the order limits, but also the its sister projects onshore in Isle of Man and the East Irish Transmission Project.
Amy Sterling on behalf of the applicant. I think the answer is ultimately interlinked by the fact the applicant has ultimately, through its real-world experience, been able to identify a maximum design scenario for these elements of the project and carry out, to the extent possible, based on these maximum design scenarios, a meaningful assessment. That's not always possible, as Dr. Carolan can explain, particularly in terms of the onshore terrestrial assets, where the certain locational elements are unknown. But based on EIA case law, EIA practice, we're confident and content that the position that we've taken is appropriate.
If necessary, Ms. Sterling, we'll probably come back to some of this both tomorrow, but possibly after even agenda item 4. But I'm going to just look around and see if any colleagues have any questions at this point. You do? Okay. Ms. Fernandez?
So if we may just focus on the East Irish East Irish Transmission Project. Are there elements of the project which forms part of the whole project that the applicant needs to update given the progress that's been made with it?
Dr. Julian Kieran on behalf of the applicant. Everything that is set out within our application in relation to the East Irish Sea Transmission Project is accurate and up to date, and there's no subsequent updates. The project has made a decision on landfall on the terrestrial export cable route, but none of those components would interact cumulatively or in combination with the Mooir Vannin generation project, so there's no requirement for any updates to assessments.
So you're confirming that the EIA does not need to be updated to reflect any updates from the East Irish Transmission Project?
That's correct.
Thank you.
Okay, can I just see if anybody has any comments on what the applicant has said? No. Right, I'm just conscious of time. It's 11:20, and we've got agenda item 4, where I do expect we will be for a while, but I am going to start agenda item 4 now, but it's possible that we might take this into session 2 as just an early warning. Okay. So agenda item 4 is a multiple part question, and what we are hoping you will do is, with the use of plans and visual aids, is to basically take 10 minutes to explain what works are expected in which precise location within the order limits. And by the way, before I go on, I just want to assure everyone that these presentations are what we call hearing submissions. They will be available on the in the examination library by the end of today. So these will be examination documents. So take 10 minutes to explain what works are expected in which precise location within the order limits. And how those assumptions are secured within the draft MIC. Justify where flexibility is sought, and also clarify whether the ES has assessed only typical parameters illustrated, or the full extent of the development that can lawfully occur within the order limits. The confirmation we're looking for over here is that the draft MIC does not permit development beyond what has been assessed. What I suggest is that you go through your presentation to cover these points, and then let's cover each question A to G in turn. But items 4B and 4C will largely be covered in a lot of detail at specific issue hearing 2. Touch on them for completeness if you need to, but I suggest we don't go into any detail for today. So I'll hand over to the applicant.
Dr. Julian Kieran on behalf of the applicant. I will run through the works in relation to the order limits, and my colleague will speak to the rest of the item. So in the presentation, the first slide, please, Tom. In relation to a definition of the development within the order limits, I'll refer to the works plans, the project description, and the draft marine infrastructure consent. This first slide just shows an overview of the works for the array, the cable, and the onshore. The next slide. So within the offshore array, we have works number 1, 2, 3, and 4. Well, they're set out from Schedule 1 of the MIC, the authorised project, which sets out the various constituent parts of those works. We have the offshore wind turbines, 87 turbines.
Can I just stop you there? Go back to the previous slide. This is not the diagram before us in terms of the order limits. And I believe this is what you've submitted with the proposed change request.
Yeah, sorry, apologies, that's correct.
But this has not been accepted into examination yet.
This is my mistake. update in this. Apologies.
Sorry?
Apologies. I mistakenly put the wrong works. Yeah.
Toby, it's on behalf of the applicant. Brief introduction. I'm an associate at Pinsent Masons. If we can get up APP-184, that's the works plans. Once it's loaded, you'll see it largely aligns with what's on the screen. It will just have the Portskillian sheet included, so it won't differ at all from what we can see here. But because it's not been included, we could load APP-184.
May I suggest, in that case, it's 11:25. We take a brief break. You sort your tech out, but bearing in mind, change request has not been an examination, so it has to be what's before us. And I will resume this session at 11:40 p.m. a.m. People online, I think you can just leave your Teams link on. You can just leave your Teams link on, go and get yourself tea and coffee, and we'll just resume. Thank you. Okay. Welcome back, everybody. The time now is 11:41 a.m. and I'm resuming session 2 of Specific Issue Hearing 2. Specific Issue Hearing 1, my apologies. Let's resume with agenda item 4. I'm not going to set out the preface, that's on record now, and we'll just start where the applicant left off.
Dr. Julian Curran on behalf of the applicant. We've now updated the works plans to be the correct version. Appreciate your eagle eye.
Mr. Carolyn, you are still again coming across a bit softly, so if you just move the microphone a bit closer.
Dr. Julian Curran on behalf of the applicant.
Yeah.
We've updated the works plans. So this plan just gives an overview. So the slides that I'm going to present are just I'm going to take mostly from the works plans, tables from the project description, and information from the draft marine infrastructure consent. This provides an overview of the proposed development and all of the works associated with the proposed development.
Mr. Carolyn, sincere apologies for interrupting you one more time. While we are aware that all of these are application documents, it does help for the sake of the recording if you always refer to the EL reference number. Carry on, please.
Okay. Yeah, so the presentation presents the works plans, which is APP 184. It makes reference to the project description at APP 041 and reference to Schedule 1 of the MIC, which is APP 191. If we can go to the next slide. This presents the offshore array and the works associated with the offshore array. We have works number 1, which is 87 wind turbine generators on the associated foundation and cables. Works number 2, 3 offshore platforms. Works number 2, 3 offshore platforms. Works number 3, it's the two cable circuits that's the island link, and works number 4, which is the export cables associated with the East Irish Sea transmission within the proposed development. We've just got a little infographic taken from the project description, which shows an indicative layout of the turbines and potential offshore substation configuration and all of the associated cables. And the next slide. So for the offshore array, we've got an indicative sequence of works, and again, this is taken from the project description. It's not set out in this form, but we have had our technical team review the project description and just set out the sequence of works for clarity purpose. So they're numbered 1 to 8. All of those works occur within the indicative construction program, which are set out within the project description. So this is repeated on a number of occasions, but just for clarity, so that people know it's a 3-year construction program, and all of these activities are sequenced. So we can see the upshore, the first bar is the onshore works, and then all subsequent bars representing the various components of the offshore construction within the overall construction program. So offshore, we have some pre-construction survey activities, the installation of scar protection for turbine foundations, the installation then of the primary and secondary structures of the wind turbine foundations. Then we install the array cables between the turbine positions and the offshore platforms. We install the offshore platform foundations and topsides. Then we install the interlink cables and export cables on joint determination and cable testings, and then install the turbines. So that's the sequence of works that occur within the offshore array, and all of those works are represented in works numbers 1, 2 and 3 set out within the draft MIC. During the construction of the proposed developments, there can be a maximum of up to 30 vessels within the offshore array and 2 helicopters at any one time. That's the maximum design scenario for offshore construction works. It's unlikely that there would ever be as many as 30 vessels in one time, but there is the potential for that to overlap in that sequence for a short duration of time, and that's the maximum design scenario carried through for the impact assessment.
Mr. Caron, I'm just wondering, there's several aspects that we want to, we're seeking clarity on. And one of the things is, what are the assumptions here and what has actually been assessed in the ES, what's secured in the draft MIC? And I'm just wondering if you might do all of that while you're telling us about these components of the project. So you've said this is an indicative sequence of works, it's an indicative construction program. It would help us understand what is that, you know, the room for maneuver in terms of the flexibility. What are you just then securing in the draft MIC, and how?
Toby Yates on behalf. Is that working?
Yeah.
Toby Yates on behalf of the applicant. So I'll take each of those in turn in reference to agenda item 4A. So to be clear, as Dr. Carolan has set out, the maximum scope of each of the works packages in Schedule 1 of the draft MIC, which is APP-191, are shown on the works plans, APP-184. The precise locations of the specific works and pieces of infrastructure within those wider areas are not sought as part of the MIC, and that's because necessary flexibility needs to be retained at this stage of the design process as part of the consent, in order to give comfort that those maximum scenarios have been appropriately assessed. The applicant has adopted a design envelope approach, and that's using the maximum design scenario, maximum design parameters that Dr. Carolan has referred to, and as are set out in the project description chapter of APP-041. And the way those maximum design scenario parameters are used is on a topic by topic basis. So each topic will identify which parameters within that maximum design scenario will represent a reasonable worst case assessment, and that aligns with what under the UK regime we have as the Rochdale envelope approach. So by way of example, I'm not a technical lead, but a helpful example is by reference to a noise assessment for piling activity, for example. The specific location of where that piling may be carried out might vary depending on the receptor to which the assessment's being carried out against. So for example, if you're assessing noise against the location of a fish spawning ground, the location of where that piling is carried out may differ within that wider works area when assessing piling in relation to fish and navigation, or sorry, shipping and navigation. In terms of how that's then secured, as I say, is by reference to the works plans. And if you look at Article 4.1 of the draft marine infrastructure consent, that clarifies that subject to the provisions of the order and to the requirements, which are set out in Schedule 2, the undertaker is granted marine infrastructure consent for the authorised project, which is each of the works packages at Schedule 1, and that is to be carried out within the order limits, and the definition of order limits then makes reference to the works plans. So what that all brings together effectively is the maximum scope of the consent is controlled by the requirements, is only as so far as shown on the works plans, and that is secured through Article 4 of the MIC. Now, as I say, a key part of that is that the works that are carried out and the flexibility that's been sought is then actually suitably controlled and mitigated, and that's through the various provisions that you'll find in the requirements in Schedule 2. And the drafting of those requirements ensures that prior approval of final versions of those plans that will be submitted pursuant to the requirements will be approved by the DOI, and that will be when additional design information is available at a later stage post-consent when coming to discharge those requirements. For the purposes of the examination, the applicant has provided outline versions of those plans, and there's a suite of them available in the examination library. We can add references in our written summary, an example being the Outline Code of Construction Practice, APP-193. And for clarity, the applicant is intending to submit an updated suite of those outline plans at deadline 2 to give some more detail based on the iterative nature of the design process and additional detail on the mitigation that's now available. And sorry,
carry on.
I was just going to add, so that's one way in which the scope of the works is controlled, and that is in relation to mitigation outline information that's available. However, in relation to the maximum design scenario more specifically, there's also requirements on the face of the draft marine infrastructure consent, which secures specific design parameters where that detail is known, both offshore and onshore. So, for example, offshore design parameters are secured explicitly in requirements 8 to 11 of Schedule 2, and you'll see that the parameters there align with the maximum design parameters in the project description. And then equally, onshore design parameters are secured in requirement 25 of Schedule 2. I was just going to come on to the next point of your agenda item 4A there, and the clarity sought as to whether the ES has assessed only typical parameters. And it was just to confirm that it's not typical parameters. As I've explained, it's a maximum design scenario within which a reasonable worst case assessment has then been brought out of that scenario. So it's not a typical parameter. And as Dr. Carolan has explained, that sort of typical or likely approach will be within that maximum design scenario, but isn't what's been assessed, because we need to ensure that the flexibility that has been sought has been assessed in full. So what that means is that the likely or typical parameter that will potentially be brought forward within that scope leads to effects that the examining body can have confidence has been assessed as part of that broader assessment. And just to finish on the final confirmation sought in this agenda item about whether the draft marine infrastructure consent permits development beyond that which has been assessed, to confirm it doesn't do that. Schedule 1 of the draft marine infrastructure consent sets out precise descriptions of the works packages which form the proposed development, and they're the elements of the project that are described in the project description chapter. That's what's been assessed for the purposes of the EIA in the environmental impact statement, and as I've explained, that's controlled through the requirements at Schedule 2. So what that means is that anything that is not defined in the draft marine infrastructure consent is not authorised.
Thank you, Mr. Yates. There's a few points that I want to follow up on, but I will be following up those points, particularly with respect to the requirements, the wording, and some of the articles through written questions. And as far as the updates and in terms of the details in the outline documents is also coming through written questions, but also later in the agenda item 7, I think. So that is a helpful overview. I was just wanting to come back to Dr. Carolan if there was anything further, because I believe I did interrupt you mid-flow. So is there anything further in terms of your presentation, or can we move on to agenda item 4B?
Dr. Carolan, on behalf of the applicant, in preparing for most of these agenda items today, I think we have circumnavigated a lot of the presentation that the applicant has prepared, and in relation to this, specifically as with the use of plans and visual aids, to take 10 minutes to explain what works are expected in which precise locations within the order limits. So, I mean, I haven't even started on that. So are we just bypassing that? No, we're not, Mr. Carolan. And yeah, let's get on to that aspect. I think one of our concerns on this end is that the picture quality, at least of the slide that you've got up at the moment, is quite poor. Let's get on to the next slide and see whether that is better. Otherwise, we might need to think. Right, so the text, I can't see it at all. Is there anything we can do about that? No, it's even worse over there.
No, it's just a low resolution.
Yeah. people in the back of the room like this. Yeah, they will not be able to see.
Okay.
So here's what I'm going to suggest in the interest of... let's carry on with the presentation, but let's make sure that this presentation is available in the examination library, perhaps over lunch, if that's possible, Mr. Randall, so that people can refer back to it. But yeah, let's...
Dr. Kieran, on behalf of the applicant, I'm happy to bypass this and provide it in writing at a better quality if it's not suitable for people to view. I'm also happy to progress whatever you think is most beneficial in the interests of this hearing.
Yeah.
Yeah. So in relation to, I think we skipped the previous slide set out the sequence of activities of the offshore array, and then these...
Sorry, Mr. Carolyn, I've had a suggestion from my colleagues, which is that given that this is such poor quality and, you know, for fairness to other parties attending, I am just wondering if we go to agenda item 5 and then pick this up after lunch. Would anybody have an objection to that? I'm just looking at parties to my right particularly. Would that be okay with the applicant? Yeah? Okay. Yeah. Excellent. So let's move on to agenda item 5. There was a certain logic to my agenda, so having missed agenda item 4, there's a chunk of that logic is now missing. We'll carry on. So okay. Carry on.
Just what we're asking the applicant to do is to revisit their presentation and to prepare it for the benefit of people at the back of the room who will be looking on a screen over our shoulder or in other places. So can you please have that in mind when you are putting the presentation together over lunch? Perhaps it's a case of high resolution and less information per page, so that people that are participating and listening today can see it. So if you just keep that in your head when you're redoing it. I don't think it's a question of throwing the baby out with the bathwater, but probably putting less information in a slide and more slides. Is that understood? Thank you.
Okay, so we broadly now have that context of, you know, in terms of the whole project and what's within the order limits. And having had that, you know, that context, what we want to now look at is the instrument which would give effect to the authorization, which is the draft MIC itself, and about how the proposed consent document itself is structured and legally framed. And what we want to understand is two things. First, how the draft MIC has been derived from the statutory framework under MIC, under MEMA, which establishes a regime for authorized controlled marine activities. And second, the extent to which the drafting reflects precedents from the Planning Act 2008 DCO regime, and whether there is, that approach is appropriate in circumstances, that approach is appropriate in circumstances where the statutory framework in the Isle of Man operates differently.
Toby Yates on behalf of the applicant. Yes, and we'll cover off agenda items 5A and B, I think, with a single answer. Mm-hmm. So just to start by confirming that the draft MIC, again APP-191, is modelled on a draft development consent order, which would be sought under the Planning Act 2008 in the UK for a similar development. And that's on the basis that MEMA 2016 is broadly modelled on the Planning Act 2008, so the legislative framework for the order is broadly similar. And of course, this is the first application for a marine infrastructure consent under MEMA, and therefore there is no Isle of Man precedent for the applicant to rely on under MEMA. And it's explained in our explanatory memorandum, which is APP-192, it's paragraph 2.3. And that explains that where parallels can be drawn to analogous regimes in other jurisdictions, namely the DCO process under the UK's Planning Act 2008 for NSIPs, such guidance and process has been considered by the applicant as set out in the explanatory memorandum and its other application documents. That paragraph continues to explain that the model provisions, which are often and routinely relied upon as the basis for a draft DCO, have also been used here for the basis of the draft marine infrastructure consent. And in our explanatory memorandum, for the benefit of the examining body and the Council of Ministers, we've explained where we've departed from those model provisions, and the intention there is to explain where we've gone for non-standard drafting for similar developments. Now, the example that the draft MIC has been based on is the Hornsey 4 offshore wind farm order 2023, and that is because it's the most recent offshore wind farm DCO that Ørsted, who is the overarching developer for that order and this proposed development, that's the most recent DCO that's been consented in the UK for that developer. But then, to be clear, and what can be seen from the applicant's responses to the various consultee comments, is that the applicant has also taken into consideration more recent DCO precedent, and that includes the Mona offshore wind farm order 2025, Morgan offshore wind farm generation assets order 2025, and the Morecambe offshore wind farm generations assets order 2025. That's a non-exhaustive list, but just some examples of the recent precedent we've considered the draft MIC against. And that set the framework for the starting point for the draft MIC. But then, recognising that this is an MIC and not a DCO, the applicants then, of course, ensured that that draft document aligns with the legislative framework that is available under MEMA and the Marine Infrastructure Consenting Process Regulations 2024. The specific provisions we've considered that draft document again is Section 37 of MEMA, Schedule 1 of MEMA, and then Regulation 41 of the Marine Infrastructure Consenting Process Regulations.
Mr. Yates, I think if you go into detail into all of those regulatory legislative frameworks, that would really help us. If you're about to do that, that's good.
Oh, I was going to say, I've got that in my notes, whether you wanted it now or in writing, I was going to offer, that's fine.
Yeah.
So to start with Section 37 of MEMA, which relates to the content of a draft marine infrastructure consent, subparagraphs 2 and 3 of that section state that a draft MIC may include requirements in connection with the controlled marine activities or associated marine activities. Now, the draft MIC includes those at Schedule 2. Subparagraph 4 of Section 37 of MEMA, that provides that a draft marine infrastructure consent can include provision relating to or to matters ancillary to the controlled marine activities or associated marine activities. That's captured as part of Schedule 1 authorised project of the draft MIC. Subparagraphs 5A and 5B of Section 37 of MEMA relate to the application, modification, exclusion, amendments, repeals or revocations of statutory provisions. That's provided in the draft MIC at Article 7. Subparagraphs 5D of Section 37 of MEMA then relates to provision for the entry into agreements between the applicant and the department is defined in the order as the Department of Infrastructure. An example of that in the draft MIC is Article 14.1, which provides for the undertaker to enter into agreement with regards to roads with the department. Subparagraphs 5E and 5F of Section 37 of MEMA continue to relate to the transfer of benefit or liabilities, and that's dealt with at Article 6 of the draft MIC. Subparagraph 5G of Section 37 of MEMA then clarifies that a marine infrastructure consent may include provision in respect to the decommissioning of anything established under the consent, and that's dealt with in a specific context of safety zones at Article 17.4, but then more generally as a concept of decommissioning through Requirement 7 of Schedule 2. And then finally, Section 37, subparagraph 6, just for completeness, lists what a draft marine infrastructure consent may not include, And just for the record, the draft MIC doesn't include any of those matters set out in subparagraph 6. Turning to Regulation 4.1 then of the marine infrastructure consenting process.
Do you want to go into paragraph 7?
Bear with me whilst I get it in front of me. Toby Yates on behalf of the applicant. The applicant's reviewing the draft MIC and the relevance of that provision and how it conflicts with the draft MIC, because at the moment you'll see from Article 6 of the order that the benefit of the order is for the undertaker, which is slightly different from the drafting of MEMA. So we'll update the draft marine infrastructure consent at deadline 2 and explain provisions that will include in the explanatory memorandum, and that will disapply that provision at 37.7 of MEMA. I'll pause there and continue on to the regulations.
You can
So
on, yeah.
Regulation 41 of the Marine Infrastructure Consenting Process Regulations, subparagraph 1, that sets out that a draft MIC must include a provision specifying the period before the end of which a controlled marine activity authorised by it must be commenced, if that period specified is different to the period prescribed in Regulation 42. The period in Regulation 42 is 5 years, and the applicant is seeking 7 years.
7 years.
And therefore it's set out in requirement 1 of Schedule 2, which therefore meets the requirement of Regulation 41, subparagraph 1. Regulation 41, subparagraph 2 then says that it may include a provision enabling different aspects of the proposed controlled marine activity to be implemented to different timescales. That's dealt with at requirement 4, stages of authorised project in Schedule 2 of the draft MIC. And then finally, subparagraph 3 of Regulation 41 says that a draft MIC may be phrased to refer to the maximum extent of the proposed control marine activity. Discuss this in detail around the works plans and how they control the maximum extent, but in terms of specific provisions in the maximum design scenario, that's requirements 8 and 9 of Schedule 2 in relation to the wind turbine generators, for example, and the offshore platforms. And then for the onshore parameters, that's requirement 25.
Mr. Yates, I just wonder if at this point it might be helpful if the definition of the authorised development does in fact reflect the scope of controlled marine activities under MEMA. And if you do want to refer to a diagram that is currently in one of your documents, in the application documents, that would be fine.
Yeah, we can come on to that. Let's
do
fine.
that.
I'll talk through it. I'm not sure that a diagram's required for the explanation. If that would help, then obviously do jump in. Maybe the works plans could be shown, but I don't think it's necessary. So just to set the legislative context here before then explaining how the MIC achieves that, controlled marine activities has the meaning given to it by Section 6, subparagraph 1 of MEMA, and that sets out a list of potential controlled marine activities. Those relevant for the proposed development are those at subparagraphs 1A, which is the laying of the offshore renewable energy generation, and also Section 6, 1C, which is the laying of submarine cables. And you'll see at paragraph 2 of Schedule 1 of the draft MIC, that defines the authorised project for which the consent is being sought. And that explains that it comprises offshore renewable energy generation and the laying of submarine cables. And it continues to explain between the seaward boundary of the Isle of Man territorial sea and the point 250 metres landward of the mean high water mark.
Mm-hmm.
So the reference is there to offshore renewable energy generation and laying of submarine cables in Schedule 1 of the draft MIC is used to directly align with the language in Section 6. The reference that continues to the seaward boundary is then to align with the scope of controlled marine area, which is defined in Section 7 of MEMA. Do ask me to pause if I'm throwing too many references at you. And then the reference to the limitation of the 250 metre landward aligns with Regulation 6 of the Marine Infrastructure Consenting Process Regulations 2024. So that initial explanation is used in the draft Marine Infrastructure Consent to make it abundantly clear that the scope of the works being sought aligns directly with the scope of the legislation. And then just taking each work number in turn, as Dr. Caroline ran through briefly before. So work number 1 relates, and I'll paraphrase here, but broadly to wind turbine generating stations. That falls within the offshore renewable energy generation used from MEMA. Work number 1 also includes works for a network of array cables, and that falls within the laying of submarine cables.
It's just in the interest of time, that particular comparison would be very helpful with the presentation that Dr. Caroline's about to do. So if you could just, if we do that with the presentation, that will be helpful. So that's fine. If there's any other content that you'd like to deliver, let's get on to that.
Sure. The only bit, Toby, it's on behalf of the applicant, the only other bit that I wanted to add is in relation to work number 6, and we can obviously pick that up too. But where I would have got to there is that work numbers 1 to 5 each fall within either the offshore renewable energy generation or laying of submarine cables in accordance with MEMA as the controlled marine activity. But for completeness, Section 5 of MEMA also applies to associated marine activities, and Section 8 confirms that a marine infrastructure consent may include consent for the carrying out of those associated marine activities. The definition of what an associated marine activity is set out in Section 6.2 of MEMA, and that says an activity if they are required in connection with any of the activities in subsection 1. So that's obviously a very broad provision, and the applicant's position is that that would then include work number 6, which relates to landfall associated assets and connection work. So that's the onshore works that were being discussed earlier, as well as the list of works that are provided at paragraph 3 of Schedule 1. For additional detail on the onshore works, you can see the applicant's response to work number 6, landfall associated assets and connection works, in its PDR 008 that was provided in response to an earlier procedural direction.
I think on that particular point, and it's possible it is best explored more because of in the interest of time, but also because it's not included in the agenda here, through through our first round of written questions. But the justification for how the order limits in the landform, basically work number 6, what point do you stop? Is at the moment, that justification is unclear to the examining authority, examining body. So I think we will be seeking further justification on that point. If you'd like to go into it very quickly right now, do.
Toby, it's on behalf of the applicant. So visually it's shown by the extent of work number 6 on the works plans APP-184. And I'm sort of told there that the intention or the need for that is because there has to be a point at which the cables from the offshore generating station can be brought onshore so that they then can be taken forward to the ultimate point of connection that Manx Utilities were discussing earlier. There's got to be some point onshore at which that onward connection is then made.
Ms. Sterling, would you like to come in at this point?
Amy Sterling on behalf of the applicant. Yeah, sorry, it's quite clunky to move the mic around, so I was trying to avoid it if I could. But yeah, essentially it's the transition joint bay. Okay. The cable can't just be cut essentially at landfall. That's not how an electrical system works. So the cables have to make landfall and be made safe within a transition joint bay. That is how work number 6 has been identified.
Okay.
And it is within that transition joint bay that the offshore cables would be jointed to the onshore cables or cable, depending on the final electrical connection for onward transition. So it's all driven by the transition joint bay. I'm probably reaching the extent of my technical knowledge, so we can provide more detail in writing and in response to any written question you have on that point. Thank you, Madam.
Okay. Just on that point specifically, because it just feels like something where the examining body would like it to be corroborated. I do wonder if Manx Utilities or Department of Infrastructure might want to weigh in, particularly if you disagree with the applicant. No? I've got Mr. Robert Garden wanting to make a comment.
Thank you, Robert Garden, on behalf of the Department of Infrastructure. I don't think we disagree with the characterisation that Mr. Yates has given on behalf of the applicant in relation to the works packages and their ability to fall within those definitions within MEMA and the regulations as well. So no dispute there. We do have comments on the form of the MIC, but I imagine they will come to either later in the agenda or through written questions, given your comments recently. So nothing else to add at this stage.
Mr. Garden, give us an indicative idea where you'd like to come in later in the agenda.
Yeah, so there are specific, Mr. Garden, on behalf of the Department of Infrastructure, there are specific comments in relation to the timeline for approvals, the principle of deemed approvals, the appeals process, and particularly in relation to non-determination, the approach to management plans, although I think having heard from Mr. Yates on the applicant's intention to update those in deadline 2, we may be able to skip those. And then particularly the approach to both safety zones and to future changes in relation to the draft MIC.
So again, this is a tricky one, but a lot of these have been picked up through written questions. But I do see a really good place for us to talk about deemed approvals and indeed the approach to outline management plans, because that is in this agenda item. But do ask your questions. If we're able to accommodate, we will. But those 2 points we will definitely cover off later in the agenda.
Thank you.
Okay, thank you, Mr. Garden. Okay, was there anything further with respect to agenda item 5 that you wanted to cover off, Mr. Yates?
No, thank you.
If I may, Mr. Yates, just in relation to the reference to stages of the authorised development, it's not clear to me where stages are a definition is provided or for in the deemed marine infrastructure draft marine infrastructure consent, and therefore the clarity of that requirement is lacking. Can you explain a little bit more what is meant by the word stages?
Toby Yates on behalf of the applicant. So I'm leaning and trying to talk to you at the same time. So the detail in relation to stages will be provided post-consent pursuant to that requirement. It's not intended that there's information at this stage as to the stages of development. And you'll see in that requirement it sets out that a written scheme setting out the stages of construction of the authorised project needs to be submitted to and approved by the department prior to any part of the authorised project commencing. So that's exactly the intention of the requirement, is that where there is going to be stages to the construction of the authorised project, that detail will be provided post-consent to the department for approval.
And yes, please go on.
Amy Sterling, on behalf of the applicant, a worked example may assist. For example, an offshore wind project, we're talking about the programme of installation that Dr. Caroline began speaking to, and we'll pick up after lunch. And in relation to the electrical connection cable, in this instance is an example to the Isle of Man, it would be unusual as a construction activity that would all be undertaken at exactly the same time. So what the requirement is intended to do is to allow the applicant to discharge, for example, an environmental management plan in relation to the landfall works, to allow it to commence the landfall works and lay the ducts at landfall before it has finalised details of all environmental requirements in relation to the laying of the array cables, as it were. And that is required, that level of flexibility is required, is because some activities may be weather dependent, supply chain constraints, that sort of thing. So ultimately, it's not possible at this stage to identify exactly how the scheme would be broken up, if at all, to progress to construction. This is a relatively standard requirement now in offshore wind DCOs, which allows the applicant at a later stage to identify essentially its programme of activities for constructing the proposed development, have those approved by the Department of Infrastructure in advance, and then seek to discharge its management plans in relation to those particular stages.
And to follow that through, stages therefore would be activity based, geographically based, or a combination of both. I mean, what's the parameter for a stage in the way that you're understanding it?
It's Amy Sterling on behalf of the applicant. It's a combination of both. It may be activity based, or it may be location based. The applicant may decide, for example, to carry out construction of the offshore platforms within one particular area, whilst also carrying out as a different stage the installation of turbines in another particular area. Those are different activities in different locations and may form different stages, all of which will be identified based on further environmental and technical design work, and ultimately subject to the approval of the Department of Infrastructure pursuant to the requirement.
And how would the DOI understand or be aware of the completion of that stage? How would they know it was completed? What is the provision within the draft MIC for that?
Amy Sterling on behalf of the applicant. The MIC does contain provision for the undertaker to notify the Department of Infrastructure in relation to completion of construction of the offshore works. It may be that we can, your point is taken, we may look to update the requirement to say notify completion of construction of the relevant stage of the offshore works rather than the offshore works in its entirety.
For sure, that would be very helpful. And more than that, if we could put some colour around what those stages are, I'd like you to explore how far can you go in defining that. And part of my question is framed in the context of the whole project, and that there are perhaps wider things that may have an effect on what is included within this proposed development, but being clear about the stages of this proposed development would be helpful.
Amy Sterling on behalf of the applicant. Yes, I think I've probably gone as far as I can go without the relevant technical input at this moment in time, but it's certainly something we can take away and respond to in writing and try to set some more specificity around what the potential stages may comprise.
I'm looking at Dr. Carolan, who looks like he may have some further elucidation to make.
Dr. Julian Kerr on behalf of the applicant. I think in just discharging one plan, it might be good to use the underwater noise mitigation strategy as an example of how various different stages and components and parts of the project may be discharged in relation to that plan. So stages may relate for the purpose of underwater noise to the cable, the export cable, and to the array, and then a part of that may relate to the location and the detonation of, say, unexploded ordnance, for example. So we would come out, we would detect that. That would be one of the sort of the preliminary site investigation, site preparation activities. So in relation to the stage of the plan would be the preparatory works, which would be like a pre-construction activity. So you would come out then, you could discharge part of the plan in relation to underwater noise just for the array for unexploded ordnance, but you wouldn't be discharging all parts of the construction noise mitigation in relation to pile installation, which would come at a separate component or a separate stage of the project. So that provides an example of how we need to break that down to manage the discharge of that requirement on the environmental management. I don't know if that's helpful, but we can elaborate in more detail in writing.
Yes, I think we would certainly find that helpful and by deadline 1. But may I just ask our DOI colleagues, as ultimately, if this project were to be consented, they will be responsible for discharging requirements, if they have any observations that they'd like to make at this point? Yes, I'm looking at you, but I should be looking at the screen. Mr. Garden.
Apologies for being virtual again. We have considered this, and one of the requests that we made in the consultation response, which is document PCR 171, is around staging to be addressed in the implementation plan. I think in principle the approach is understood and accepted in terms of the requirements, but some clarity around that would be welcome from the department's perspective. And I think to your question in relation to the whole project, one thing we will also consider is whether any controls that are necessary in respect of the linkage between the works consented pursuant to the MIC and any future consent that we'll submit. And we'll submit that to you at deadline 1 as well.
Thank you, Mr. Garden.
Thank you. Thank you, Ms. Fernandez. I think that hearing action will be quite a crucial one. Can I just tag on something to that? And this is something that I am covering in written questions. But whether any of this in terms of stages is going to get affected, or potentially how that interacts with the definition of commence or commencement, will be very important to understand. And indeed, if there is potentially a loophole for the discharge of some of the finalised management plans because of the staging of activities, and therefore, you know, and the effect that has on commencement and the discharge of management plans.
Amy Sterling on behalf of the applicant. I think I'll have to reflect on what you've said to ensure that,
So
and then I can respond in writing, which I think is what you're suggesting.
Yeah, absolutely. Yeah, that's fine. So, sorry, your question is that you're going to reflect on it and then respond to it in writing?
Yes.
Oh, yeah, no, that is my hearing action, is that I'm tagging on to what Ms. Fernandez said. Okay, now, in the interest of time, I'm just going to review the agenda very quickly. I'm content that 5 has been covered. Applicant and parties in the room, any further questions on 5? Ms. Pownell, you wanted to come in.
I just wanted to ask DEFRA if they had any comments to make on the consultation in terms of discharge of requirements.
Ken Milne here on behalf of DEFRA. Yes, we understand that the MIC is the discharge of requirements is a DOI matter. However, if we ask for anything environmental, fisheries, anything relevant to the Department for DEFRA, Environment, Food and Agriculture, obviously we're consulted with in all of those, and we would expect to approve those plans, procedures, process, etc., to feed back into DOI's approval process.
Thank you, that's very helpful.
Okay, now agenda item 6. What I'm going to do is I'm going to put this in written questions, but I think that there are chunks of this. I'm just going through my written notes. We have covered a few bits of it, but what's left, I'm going to put this into written questions. So I'm looking at parties in the room and on the screen. If there were any questions on, then place them to me now for agenda item 6. Mr. Kiln.
Ken Milne, on behalf of DEFA. We just have an observation to make for item 6. It was that a number of the parameters listed here don't seem to match the maximum design specification in the EIA. For example, the embedment depths, scar protection areas, which could have an impact, different impacts on those assessed. Additionally, a number of the relevant items are not included, such as the maximum cable burial parameters, drilling activities, volume of sediment disposal, and cable crossing protection. We'd just like to raise that point. Okay.
That is good. I'm just wondering, looking at the applicant, I think it would be really helpful for us to get a quick response to that now. But it's something that we will be exploring in greater detail through written questions anyway, and actually possibly at SIH2. No. Yes. So.
Amy Sterling on behalf of the applicant, any discrepancy would be an error, so we will check and if necessary update the draft MIC. It's certainly not the intention that the draft MIC doesn't reflect the maximum design scenario within the project description.
Thank you.
And Mr. Milne, I'm just confirming that these discrepancies have already been noted in your public consultation response?
We did make sorry, Ken Milne, DEFA. We did make reference to it. If you want a specific example, example on the APP 041, tables 13 and 14, the embedment depth for monopiles is given as 50 metres in the EIA, but here it's 80 metres. And the pin piles values are 90 metres and 120 metres respectively. It's just one example.
Dr. Julian
Carolan. Yeah. Mr. Carolan?
Dr. Carolan, on behalf of the applicant, we're aware from our consultation with DEFRA that there are a number of parameters that there may be mistaken values between what is in the MIC and what the MDS is within the EIA. And we're going to seek further clarification on a full list of those. We're aware of 2 examples.
I was just going to ask
we'll
that.
Get a list of DEFA of all of those examples, and we'll provide then a cross-check and clarify the correct values.
Yeah, so this is, so that was just going to be my next questions, that if there isn't a full list in your public consultation response, I'm going to suggest that that's communicated to the applicant ahead of deadline 1, if that's even possible, so that the applicant can then respond at deadline 1. So if that communication can happen behind the scenes, that'd be good. But I will note this in hearing actions. And then, okay, good-o. Anything further on agenda item 6 from any parties? I don't see any hands up. No? Panel? No. Okay. I'm going to move on to agenda item 7 because, Mr. Erling, you have already alluded that you've got a few updates that you would like to bring to us. So I'll just introduce this and then hand over to the applicant. So agenda item 7A. What I'm looking for here is basically what mitigation measures are relied upon to manage and mitigate the environmental effects of the development. Now, in particular, what we want to understand is what is the applicant's approach to securing mitigation. So what principles were applied when deciding which mitigation measures are secured directly within the consent, either through articles or requirements, and which measures are then instead deferred to post-consent approvals through requirements and management plans. And if you want to refer back to some of your approach where you've relied on the statutory framework provided by MEMA in order to construct your draft MIC, then that read across will be very helpful for us to understand when you're answering this question.
Toby Yates on behalf of the applicant. So the approach to secure mitigation is generally split into two approaches. The first one being the specific measures that are secured through the maximum design scenarios, and then secondly the outline measures that are secured in the outline plans that are then secured pursuant to the requirements that reference those plans. So in relation to the maximum design parameters, I touched on it before, but for offshore design parameters, they're secured expressly in requirements 8 to 11 of Schedule 2. And then there's also...
Sorry, Mr. Yates, I just want to clarify that the design parameters that have been secured in the MIC, haven't you referred to them as embedded mitigation in your approach to mitigation?
Yes, they're embedded into the scheme design, correct.
While it's very helpful to have that context, what I'm mostly interested in is the additional mitigation mitigation measures that you intend to put in place in order to mitigate some of the adverse environmental effects.
Toby Yates on behalf of the applicant. Okay, understood. Again, an example here may be useful. Most appropriate one we can give is in relation to the underwater noise management strategy, and that's secured in requirement 20 of Schedule 2. And an outline of that strategy is being provided at APP-203, and that includes examples of noise mitigation measures that could be implemented to achieve non-significant effects, but the precise measures proposed are not themselves committed to at this stage, and they don't represent an exhaustive list of the measures that may then go on to be provided in the final plan. And that's because when the project design is finalised, there'll be more information available to the applicant at that stage to inform the final mitigation measures that will be included as part of that final plan to be submitted for approval in order to control the effects of the development.
Forgive me, Mr. Yates, but that seems a little bit back to front to me. Given that you've done the environmental impact assessment and you have an idea of the adverse effects, you also know which of those adverse effects need to be mitigated. Those measures should be clear to you, whether it's the implementation of those measures, and I'm talking about how this is approached usually in other major infrastructure projects. How those measures are then eventually implemented is what is left to detailed design and post-consent stage. So I'm just trying to understand how you're approaching mitigation and saying that the mitigation itself, the mitigation measure itself, is what's going to be determined after you have further design details about the project.
Amy Sterling on behalf of the applicant. I mean, I would say that this scenario is probably specific to noise, and other major infrastructure projects, both onshore and offshore, don't tend to commit to the final noise mitigation measure at the point of application or indeed consent, because ultimately what may be the most effective noise mitigation measure will ultimately be dependent on detailed design. And so the applicant has taken a very standard approach to noise mitigation specifically by not identifying the technology at this point in time that will be used, but nevertheless committing to mitigating and are based on a range of known and available mitigation measures at this time. It's quite difficult, in all honesty, to talk about mitigation generally across the EIA. It's quite technically specific. If there are specific questions about how the mitigation hierarchy has been applied in relation to a particular topic or a particular receptor, we are of course happy to take them now. If Dr. Carolyn could answer them, great. If not, we could respond in writing. There are other examples and other management plans where the applicant has committed to specific mitigations under that management plan. I guess the key point is, in our submission, it doesn't necessarily matter if it's in the management plan or in the face of the MIC. The mitigation is equally secured. That's been confirmed very recently by the Secretary of State in the Outer Dowsing Development Consent Order decision, where, on request of the MMO, the Secretary of State refused to carry some of the mitigations that were in the underlying management plans onto the face of the DCO because it was unnecessary. The plan itself was secured via requirement. Some of the mitigations don't lend themselves to statutory drafting, which is ultimately what the MIC are. They're contextual in nature, difficult to construe in accordance with interpretation principles, hence why they may be process-based, hence why it's more appropriate to have those sorts of mitigations within the management plans. This is perhaps something in terms of the approach to identifying which mitigation was in the plans and which mitigation was in the MIC. It probably has to be on a topic, at least by topic basis, and that was something I'd have to come back to you in writing, I'm afraid.
Yeah, Ms. Sterling, that point is understood, and I think you are right that it is difficult to talk about mitigation generally across the board, and we will be picking up detailed components of that, a lot of them tomorrow, and then of course at SIH3 as well, and indeed through written questions. But I think what we have found generally is that the content in some of your outline management plans and some of the control documents is at this stage does not lend confidence to the examining body that there is enough in there for the for the receiving environments and indeed for the examining body to reassure the Council of Ministers that the adverse effects of these projects will be mitigated. So, for instance, what mitigation measure you put in place is to be determined later. That's fine, but what would be the acceptable level? That is something that we would like to see secured in the draft MIC, or potentially in a control document that is secured through the MIC. So, but yeah, we quite specifically on the control documents, we will be covering this tomorrow and through written questions. But if you just give me your response on that point.
Amy Sterling, on behalf of the applicant, yes, the applicant is aware of the need to update the outline management plans, in particular in response to, for example, the consultation response from DEFA. The applicant is working on those updates at this moment in time and will update them at deadline 2 of examination is the current programme. And we do have more technical experts, as it were, in the room tomorrow to speak to the various agenda items. It may be more appropriate to speak to particular mitigation strategies then.
What I'm going to do is let me hand over to Ms. Pownell, but I know that there were some questions that Mr. Garden had as well, which relate to this point. So I'll pull in Mr. Garden soon after Mr. Pownell.
I think it's probably correct that it's a very broad question, and at this stage, excuse me, it's difficult to answer. But I think what the chair is explaining is that in the ES there are moderate impacts, significant effects on species, for example, like mammals, and that at the moment it's very hard to understand how those would be mitigated through the mitigation plans. So I do understand the principles if you have a mitigation plan and it has certain infrastructure in it which specifies monitoring and mitigation, but at the moment it's difficult to understand that can be mitigated through using that plan. Does that make sense? I think that's the principle we're talking about here. So I think that's something that the examination will explore. We'll touch on it tomorrow, but I think that's what we're trying to get to the bottom of, to have confidence that they can be mitigated through the plans.
Dr. Julian Carroll, on behalf of the applicant. I appreciate the comments, and we have broadly mitigated a lot of impacts through the use of plans in the EIA, and the mitigations haven't been matured or developed. We're in the process of agreeing those mitigations now. A good example for that is the underwater noise mitigation strategy, which is probably a little bit more developed than some of the other plans, which are just basically blank documents. The underwater noise mitigation strategy but sets out a number of mitigation approaches that are they're industry approved to achieve the levels of noise reduction that is required to achieve that mitigation. What we're attempting to do now with those plans is to do some additional modelling and some quantitative work which proves the efficacy of those, and then in consultation with DEFA we can update those plans for deadline 2, and that is the process that will happen for all of those mitigation plans as we seek to get more maturity into them and give people the degree of confidence that that mitigation is deliverable and has efficacy.
Deadline 2, I'm just thinking, I'm just picturing the draft timetable in my head. Is deadline 1 not possible?
It's not possible, no. The amount of consultation, the amount of plans, the amount of consultation, the amount of stakeholders is just not feasible with the statements of common ground and with everything else. I mean, maybe DEFA and DOI can speak to it. They're the key consultees. So the amount of plans that need to be consulted on, we will have detail of in the statement of common ground on the status of those plans, on how they're progressing, and we can present that in the statement of commonality and in the statement of common ground, but it's not going to be possible to update all of those plans by deadline 1, and that's why we're saying now deadline 2.
So, Mr. Carolan, one of the questions while you were just speaking about, needing to update these management documents, was whether we then have enough time in the examination and to get, an outline from you tethered to the examination milestones, whether we will have enough time in the examination to then get responses from parties for us to be able to test them and so on and so forth. And my worry with deadline 2 is that that's going to be really difficult. So what I am wondering is if we can sift out some of the key control documents for deadline 1, which we know do need extensive consultation, and then you can, hold some others back for deadline 2. Would that approach be suitable?
It seems that you're pushing for that. We can accept it, but I can confirm now that the level of detail that is going to be in them is going to be very limited, because we won't have enough time to complete that task. So I'm happy to submit additional ones that provide you with a degree of confidence in that, but they're not going to be all materially different from those that have been submitted with application.
Well, that will not be acceptable or satisfactory. So bear with me 1 second while I confer here.
Dr. Carolan, so when we look across at your experience that Orsted has in many of these DCO NSIP applications, not accepting this is not a DCO, but I think you refer to 12, you as an organisation will have a pretty good understanding of what would need to be in the control documents. And at the moment, and I'm not going to single some out, as you've said, some of them are blank, and we could do an awful lot better, I think. So what I would suggest is draw on your knowledge of other offshore wind farms and provide the detail and respond to the questions that DEFA and DOI have made in response to those code of construction practice or the LEMP or whatever, and submit that at deadline 1, and we will be asking you some first written questions on it. We are not expecting the finished article, but we would expect an article that has started, and some of them are pretty disappointing. So do what you can, but certainly we would be expecting something a lot more substantial than what we've received so far. But fully understanding this is not going to be the finished article.
Amy Sterling on behalf of the applicant. Yes, that's understood. The applicant will do that for deadline 1. I think what Dr. Carolan was perhaps presenting was what we would have preferred as sort of the gold standard. We would have preferred to engage with DEFA, engage with the DOI and agree the text, the wording of those management plans before submitting into examination. So we would have essentially front-loaded the consultation process, but I appreciate that you have an examination timetable to run, and therefore that consultation process may take place post-submission of the documents rather than in advance of the submission of the documents, which we would have preferred on our timetable. So yes, we will update the outline plans, submit them at deadline 1, and those can then be consulted on. If it is possible to consult with the Isle of Man Government on any particular elements of those plans in advance of deadline 1, we will of course continue to do that. Thank you.
I just want to bring in Ms. Pownell at this point.
I just wanted to follow up on what my colleagues just said. I think there was a quite sophisticated evidence-led process with tag groups where all were involved. And as my colleague says, also they're very experienced in these applications. And it's not the first time they've submitted management plans to mitigate effects. So the underlying principle has to be the EIA has identified significant effects, and we need to do some thorough work here to get to the bottom of how they will be mitigated. So I think what my colleague suggested is using your previous experience to produce something for deadline 1 across the board, to be honest, is very helpful. It's not ideal, but it's helpful. And then with colleagues in the other departments across this panel and everybody, we have to get to work to create something at the end of the day and the end of the examination that actually works and is robust.
Does that complete your point? Mr. Smith?
Yes, and in response to that, and essentially trying to condition this approach to a gold standard set of documents, yes, of course, in an ideal world, you would have liked to have carried out a full round of consultation with a broad range of parties before deadline 1, but you won't have time. However, an examination is itself an inherently consultative procedure, and I just wanted to remind us all of that, and therefore, if anybody needs to make comment on those at deadline 2, inherently that is their right. And returning to the remarks that we made on timetabling at the preliminary meeting yesterday, part of the critical importance here is maintaining the rhythm of engagement. And I think if we proceed as I think we are all very clear we can, in a slightly suboptimal way, then the natural process of consultation will follow on, because any person who is interested in the content of that material will be able to respond at deadline 2.
Ms. Sterling, as I and Dr. Carolyn, as I was saying, that what I have in front of me is the examination timetable, because we have kicked it off now, so the clock's ticking. What will then be helpful for you to submit alongside it is, alongside the examination timetable, how do you envisage seeing this through within the examination timetable to a point where it is agreed from, you know, a blank document to a document which is accepted and agreed with relevant parties?
Amy Sterling, on behalf of the applicant, yes, we can provide a programme for
That's
the documents.
Good.
Thank you.
Okay. I think we've effectively covered off agenda item 7B. Does anyone have any further questions for the applicant or for the examining body? Mr. Mill.
Ken Mill, representing DEFA. Just one comment, one suggestion, if I may, panel. Given that approval of plans could be several years away for the final plans, we would suggest that each mitigation plan specifically states what has been mitigated at the start of the document, to avoid the need for us to constantly go back and refer to the environmental statement as well. Just a suggestion, if that's okay.
That seems sensible to me, Ms. Sterling.
Amy Sterling, on behalf of the applicant, yes, we agree it's a reasonable suggestion. We'll set out the scope of the mitigation in each plan, noting there are several plans at the start of the document as requested.
Any further points?
Sterling, on behalf of the applicant, no.
Okay. Just actually, I should have turned to the departments before. Just in terms of ensuring that we can move this at pace, Do you feel like you have the resource to engage with the applicant, fairly quickly and at pace in order to ensure that this can get delivered during the examination? I appreciate there'll be a fair bit for DEFA particularly.
It's Ken Milne representing DEFA. Yes, you're correct, panel. There's a lot of work for DEFA, but we have resourced up. Our intention is to work closely with the applicant to review all these in a timely manner and meet your deadlines as said. That's
very reassuring, Mr. Milne. Thank you very much. Right, with that, I don't see any hands up online. Any of my colleagues, anything further? No? Okay, so that concludes agenda item 7. We've literally gained 19 minutes, and I'm just wondering if we should probably break for lunch now. Let's break for lunch, which does mean that session 3 is going to be an extremely long one, because we will cover agenda item 4 and then move on to agenda item 9. But we will just have to manage that. So let's do that. It is 12:57. Let's take a lunch break for 1 hour and come back at 2 p.m. and we will start with agenda item 4.
Good afternoon. This is Tom Raneley, case manager for this application. This is just to advise you of a 10-minute delay to the start of specific issue hearing 1 after lunch. The live stream will formally commence at 2:10.
Okay, good afternoon. It's 10 minutes past 2. We were dealing with an accident on a table, water damage. So we had to make a delay to the start of the examination, start of the hearing. So my apologies for that. But we are ready to resume session 3. We do have a few pending items from the previous sessions. Now, I wasn't going to cover agenda item 8, which is approach to disapplication of other legislation. It's quite nuanced, and my intention was to cover this in written questions, and of course, some of it will get covered tomorrow as well. Having said that, I believe there was a query on that agenda item from this table. So if there are any comments or questions, I will take them now, and then we can see whether we want to explore that or whether we just put that into written questions. But I will take the comments now.
Inbrooks for DOI. It was just a query whether this matter was going to be raised as part of the any additional queries that were going to be part of this hearing. That was all.
Okay, so you yourself do not have a question related to that agenda item at the moment?
It was just more a procedural aspect of
Understood. Okay, all right. There is, I believe, a question on Teams.
So, Mr. Garden, on behalf of the Department of Infrastructure, again, it may be that you've got questions that you'll ask on this, but the two items that we're going to touch on in relation to the interaction with legislation were the safety zones and the approach to potential changes to the draft MIC. But it may be that those are best dealt with through your written questions.
Actually, Mr. Garden, what I'm going to suggest is that you put your questions to us, and let me just make an assessment. So, what is your query?
It's less of a query, more of an observation on the draft MIC itself. So in relation to both safety zones and changes, the applicant has included articles in the draft MIC to deal with those matters. But it was to make the panel aware that the department is currently taking forward legislation that it expects to be in place during this examination.
Understood,
to deal with both of those matters.
And do you have any timescales on that? And what is the level of engagement with the applicant on that matter, particularly in terms of the implications that might have on the MIC?
Yeah, absolutely. So in terms of the safety zone legislation, there's a consultation that's expected to be launched in March of this year, and that's expected to run for a period of 6 weeks. That piece of legislation requires an application order to be approved by the TIMWALD, and following that approval, the subsequent regulations will be introduced with the negative resolution procedure. That's expected to take place and to be laid in the TIMWALD in July of 2026, so we do expect that to be in place during this examination. And similarly, in relation to the change process, there's a draft article, Article 21 in the draft MIC that deals with non-material changes, and the government is bringing forward legislation under Section 42 of MEMA, and a consultation was actually launched on that on the 2nd of March 2026, and again runs for a period of 6 weeks. And again, the expectation is that the legislation is subject to the negative resolution procedure and laid in the TIMWALD in July 2026 as well. So again, the expectation that change legislation which deals with non-material changes, material changes, and also revocation of orders is in place before the close of the examination.
And I'll seek an opinion from the applicant on this in a minute, but what is the implication of that on the draft MIC from your point of view?
Mr. Garden, on behalf of the Department of Infrastructure. So from the department's perspective, that means that the relevant articles that are currently included in the draft MIC, so that's Article 17 in relation to safety zones and 21 in relation to non-material changes, should be removed and that the matter should be dealt with pursuant to the relevant regulations. But I appreciate that is conditional on that legislation coming forward.
Do we have any wording from this draft legislation before us? And can we have?
Not at present, but I think we can have the consultation materials before you, and probably to have those submitted at deadline 1.
That would be good. So I'll note that as a hearing action, and that would be for both the relevant legislation that relates to Article 17 currently in the draft MIC, and the one that relates to Article 21. So the one relating to non-material changes and the safety zones.
That's correct.
Okay, turning to the applicant.
Yes, thank you, Amy Sterling. On behalf of the applicant welcomes the positive progress that the Department of Infrastructure is making in relation to bringing forward the relevant legislation in relation to safety zones and change applications. The applicant considers it's appropriate at this stage, while those items are still at consultation rather than in legislation, to retain the provisions that it has within the draft marine infrastructure consent. However, the applicant's intention and expectation is that when that legislation comes into force, those relevant articles can be removed or amended depending on the nature of the legislation. And we haven't had an opportunity to fully review the consultation launched on Monday, and we haven't seen the one on the safety zones, but we will be participating in the process and engaging with the DOI in relation to these items.
Just a couple of points there, Ms. Sterling. One is that in your statement of common ground, if you can then include this as one of the points that you cover off, and in particular, if by the time you are ready to submit your statement of common ground, if you do have a look at the consultation material, and if there are any items that fall into the amber or red zone, then definitely highlight that for us. The second thing, and this is for both Department of Infrastructure and the applicant to consider, is that what if there's a delay in the process? So if there is a delay in the process and the matter does not come to the examination, then where does that leave the examining body in terms of considering this? So because one of the questions I've currently got in my written questions is that when this legislation comes forward, are you going to take Article 21 out? This was with... and, it would just be helpful for us to understand what is the implication of this not going to time and not coming to pass by the end of August or the 1st of September when the examination closes. So just include that in your statement of common ground, I think. Okay, bear with me. I will just check if my colleagues have any comments. I'm going to hand over to Ms. Fernandez first. You believe you have a question?
Just a small point of clarification for Mr. Garden on behalf of DOI. It would be helpful, I think, to include in that deadline 1 inclusion of the consultation materials, perhaps a short cover just to set out what the potential effect could be on the draft MIC should the consultation, should those changes be made in July. Thank you. I think you're on mute.
It's not
sure. We're not hearing you at the moment.
Mr. Garden, on behalf of the Department of Infrastructure. Great, thank you. Yeah, absolutely happy to provide that statement at deadline 1. Thank you.
Okay.
I'm very conscious, Mr. Gardner, of the response that you gave earlier, that you don't immediately have formal draft of the proposed legislation. But I would indicate that for the examining body's purposes, in terms of us considering what recommendation we might make on the draft MIC, that as soon as that is available at whatever relevant deadline in this examination, it will be very valuable to see it, and my sense too will be that until the applicant has seen it, they will have this pretty reserved approach to their willingness to consider drafting change as well. So yes, can we see drafts as soon as they are reasonably available, just in the same way as one might see a bill as it's placed before Tynwald, for example, then that gives us an opportunity to start to think about how we manage this.
Yeah, Mr. Garden, on behalf of the Department of Infrastructure, again, happy to provide that as soon as we have those to the examination and to the applicant as well.
Good. Anything further from you, Mr. Garden?
Not at this stage, thank you. I suspect item 10, there'll be some further points in relation to some of the points raised earlier, but nothing on this agenda item. Thank you.
Thank you very much. Okay, in that case, I'm going to move on from agenda item 8 and move back to agenda item 4. I'm not going to preface that because that's on record already. So, Dr. Carolyn, if you just kick off from where you left off, 10-minute presentation, and then we will follow up with our questions from the agenda.
Dr. Julian Carroll, on behalf of the applicant, I'm going to do this together with my colleague, Mr. Yates, so we'll interchange. So just in relation to the presentation, we've tidied it up a little bit and hopefully people can see it. If we go to the first slide, please, Tom. So just in relation to the definition of development within the order limits, this slide gives an overview of the order limits and the various works numbers associated with the proposed development. And we make reference to those works plans, APP 184, and then we'll also make reference to the relevant works as set out in the draft MIC in APP 191. Go to the next slide. So in relation to the offshore works, this shows the works plans for the offshore array, and those works that are applicable are works numbers 1, 2, 3 and 4. The next slide basically provides a definition of what those works are. If you could just pass to that, please. So for the offshore array, we have works number 1, which is 87 wind turbine generators and associated foundations, a network of array cables. Works number 2 could be up to 3 offshore platforms and their associated foundations, and that could be either a combination of up to 3 small or medium, 1 large substation, 1 large converter station, and a series of interlink cables and offshore platforms. Works number 3 comprises 3A, which is 2 cable circuits buried. 3B is 2 cable circuits installed by trenchless technique. And works number 4 is the 4 cables which form part of the East Irish Sea transmission, so exporting the power from the generation asset to grid connection at Penwortham. Any of those works can occur within any area within the offshore array. So turbines can be anywhere within the array, platforms can be anywhere within the array, cables can be anywhere within the array.
Toby Yates on behalf of the applicant, just to add there as well by reference to MEMA on the discussion earlier, work numbers 1A and 2A, as outlined by Dr. Carolan, relate to offshore renewable energy generation pursuant to...
Mr. Yates, can I just interrupt you there? Mr. Carolan, just on the last 2 slides that you've just shared, there's nothing in there which is not already in the application?
It's all in the application, yeah. Everything here is presented is in the application.
So one of the intention of asking you that question was to get further clarity on, where the joint transition bays will be and some of the other aspects of the project. Are you not in a position to provide that? Because the purpose of asking you that question, and it was agenda item 4 if you remember, was to understand the interaction between the MIC and the ES. And in order to do that, we just felt that there were certain assumptions which were pretty loose. And so we were unable to see that interaction between the ES and the MIC, the draft MIC, giving us a level of comfort that what you had assessed was actually what was getting secured and what was getting authorised. So where does that leave us now?
It leaves us exactly where we are. So we can provide clarification on the transition joint bays. The agenda item didn't specifically state transition joint bays or clarification in relation to that matter, but we do have slides on the offshore export cable corridor and landfall, and I can provide some clarity on that when we get to those slides. If you want to jump to that now, only in relation to transition joint bays, happy to do so. We can just jump forward a few slides.
Toby Yates on behalf of the applicant, just jumping in before we go there. I think this comes back to the point raised earlier where the assessment is being carried out on the basis of that full scope of works powers as shown in the works plan. So any information that would be provided more specifically than that would be purely indicative and have no bearing on the environmental impact statement and the conclusions made there. As I explained earlier, each chapter in the EIS, so each topic on a topic by topic basis, has carried out its assessment on the basis of infrastructure in differing locations within that full scope. So it would have to be done on a topic by topic basis.
Okay. Mr. Yates, why don't you carry on with what you had left off before lunch and make that correlation back to the, the statutory provisions in MEMA and the work numbers.
Sure, Toby Yates on behalf of the applicant. So just to start again then, work numbers 1A and work number 2A, they relate to the offshore renewable energy generation, which aligns with section 6.1A of MEMA 2016. And then, as shown on screen, the rest of work numbers 1B, 2B, work 3 and work 4 relate to the laying of submarine cables, which is section 6.1C of MEMA. If the slides can catch up to it will go on to talk about work number 5, and that is works in relation to cable circuits, which Dr. Caroline can talk about in more detail if that would be of interest. But in relation to MEMA 2016, again, that's the laying of submarine cables, so section 6.1C of MEMA.
Okay.
And for completeness, again, we can follow up with more detail in writing, because I understood that the intention was to focus on the controlled marine activities in this hearing. But for completeness, work number 6, which Dr. Caroline referred to in the landfall assets, and you can see it on screen, that's associated marine activities pursuant to section 6.2 of MEMA 2016, and we can explore that here or in writing.
And that was the point where you already have a hearing action to provide that further justification of why here and not a further 50 metres down. Okay, so we've got that, which is helpful. I think we are going to interrogate a lot of this landfall associated material tomorrow. So I'm just going to look around and see if there's anything further we want to interrogate today. Ms. Fernandez.
I think the agenda for tomorrow and today have many similar items, and what we're asking for is clarification on specific matters, including but not limited to construction compounds, temporary access roads. I'm reading the agenda to you. Provide details of what works has been assessed within those areas, including highways, areas in proximity to heritage and residential receptors, assumptions in respect of utility diversions and associated works, and so forth. So our expectation from the presentation today and indeed tomorrow was to give us more clarity on the detail of that. So perhaps those are in the slides that are to follow. I don't want to preempt the end of this presentation if that's what you're going on to show.
Amy Sterling on behalf of the applicant. We can certainly talk in more detail at the relevant agenda items tomorrow, as the assumptions made in the environmental impact statement on the location of the infrastructure and its proximity to sensitive receptors. However, just to be clear, we are seeking consent to put, for example, a transition joint bay anywhere within the relevant work number. We're seeking consent to put the turbines anywhere within work number 1. So we don't have, subject to detailed design, for the wind speed survey, supply chain, we do not have that level of specificity on the location of the infrastructure, and it is not intended that that level of specificity would be available during examination or indeed at the point of consent. Those would be dealt with through the detailed design requirements and considered post-consent.
And so between now and tomorrow, what we will be looking for is more detail beyond what we can see here. And there's been a pretty extensive public consultation responses from DOI, particularly on these matters. So if there's nothing further that you can provide us beyond what you have already included in the application, then I'd be looking for justification as to why you can't come further forward with information on that.
Amy Stirling, on behalf of the applicant, yes, we certainly won't be able to provide you with any firm locations of infrastructure, but we can, perhaps we'll review the agenda items for tomorrow and provide specific examples of how within the maximum design scenario the location of certain infrastructure has been identified for the purposes of assessment. I think as my colleague Mr Yates referred to, the location of that infrastructure and what represents the worst case scenario within the design scenario will change on a receptor by receptor basis. If you are piling next to a fish spawning ground, that is the worst case assessment for that fish spawning ground. If you are placing a turbine near a shipping lane, that's the worst case assessment for shipping. It will change. We are seeking consent for that design envelope. So we will certainly come prepared with examples. There will be no definitive final design within this examination or indeed consent.
And so just again to orientate you ahead of tomorrow, in the morning, the first session will be asking you to take us through step by step by step what is proposed for the landfall location. For example, where are those temporary access roads? Where would the construction compounds be? What is proposed in terms of activities, let's say on Groudle Beach area? What are those activities? What sort of vehicles? Are they 4x4s? Are they tractors, JCBs? How will they access that? That's all sort of information that we would anticipate you would be in a position to provide information on beyond what we have already seen. So that's a first session, very much on the landfall, and then later in the day we will be looking at more to do with the offshore environment, if that helps.
Amy Stelling, on behalf of the applicant, the information we have on the activities is within the project description. We are more than happy to walk through the project description and the sequences of activities. We are not able at this stage of the development to identify any further specificity. We can only identify, as I said, the worst case scenario depending on the relevant impact. We can't say a piece of infrastructure will definitely be here and this 4x4 will definitely come down here. We can explain the maximum design scenario, but we don't have that level of design.
For sure, and in explaining that maximum design scenario, then you will be able to say to us, for example, the worst case would be a vehicle like this, and it will access on this particular access road from this location. So that would, in effect, be the worst case scenario.
Amy Stelling, on behalf of the applicant, for a particular topic or receptor, and so it may change. I understand what you're seeking. I will take your comments, we'll reflect on them, we will endeavour to do our best to address them tomorrow.
Sorry, and then to hand back to you, if I may. And some of these work plans, because of the way that they have been presented, it effectively blanks out anything that's happening underneath them. So I would also ask if tomorrow you could provide plans that do reflect life underneath those hatched areas. For example, again, let's take Groudle Bay as an example, the cliff and the beach and the location of residential receptors. So from that, it's actually very difficult to understand the topography, the Groudle Glen railway line and stuff like that. So if you could just look at how you present those tomorrow, that would again be very, very helpful.
Amy Stelling, on behalf of the applicant, I will need to consult with my client, but I don't think that would be possible to do for tomorrow. These are quite complex GIS plans. We can certainly endeavour to do it for deadline 1. It's not something we'll be able to do over the course of the night, I suspect.
I'm thinking actually of probably putting Google Maps underneath. That would be extremely helpful.
Yeah, I can't commit to that, I'm afraid. I will consult with my client and see what we can do.
Just briefly on this point, it's a technical matter, but it is simply about setting a translucency on the colorations that have been used for the specific works. It's a one-click item on your GIS. It will take probably about 5 minutes.
Amy Stilling on behalf of the applicant. I note the concerns, I understand them, we'll see what we can do. I think that's as much as I can say at this stage.
And if you're unable to do it, we'd like to have a very good reason as to why.
Ms Sterling, my colleague Ms Pownell wants to come in, but I just wanted to make one point that we did rush through agenda item 6 because many aspects of it were already covered, but one of the things that I was going to put in written questions, and I just wanted to alert you to that because it is something that Ms Fernandez has already given you a bit of a heads up that will be covered in detail tomorrow, and that is the assessment of the reasonable worst case scenario within the ES. And what I wanted from you was for you to walk us through, explain how the parameters that the worst case scenarios are based on are carried through into requirements within the draft marine infrastructure consent. So that relationship between the worst case scenario and the draft MIC. I'm still going to put this in written questions, but an indication of that, if you wanted to touch on it tomorrow, would actually be indeed very helpful.
Amy Sterling on behalf of the applicant. I'm happy to take it now. The worst case scenario sits within the parameters of the maximum design scenario. The parameters of the maximum design scenario, aside from a few potential errors that we're discussing, are secured via requirement and Schedule 2 of the draft MIC. That is how the parameters that have been assessed within the environmental impact statement have been secured. That is standard practice. I'm not sure really what
I think
what
I was hoping for was that literally that line of connection between what you explain as being the worst case scenario, for instance, in terms of traffic or in terms of a particular envelope in terms of, you know, the cable corridor. I would literally like to see that tracked into the draft MIC, because at the moment we're finding a disconnect between the two things. So let's take a couple of examples tomorrow, and then I might request a schedule following that at deadline 1.
Amy Sterling on behalf of the applicant. I think it would be helpful to have specific examples that you would like to see. So, for example, at the seascape landscape visual impact assessment would assume, a maximum height of a turbine, say, of 350 metres. That's secured by requirement. There are some fairly straightforward examples. If you're suggesting, if we assume a reasonable level of traffic numbers, is that in the draft MIC? No. And we can explain why that is. But nevertheless, that would be controlled via the construction traffic management plan and ultimately subject to the approval of the Department of Infrastructure. The approach we have taken is entirely standard for this type, scale, nature of project, and aligns with EIA practice in the UK, which accords with the Isle of Man strategic plan, which tells us to look at UK best practice in the design envelope, Rochdale envelope approach. So there are...
Ms Sterling, that's understood, and yeah, that is understood. I think there are a few further questions that I have under agenda item 4, which will probably give you the kind of disconnect I'm talking about. But I do want to bring in a few other parties. I know Ms Pownell has a question, and I also know Department of Infrastructure has. But if I can go to Ms Pownell first.
There's just observations, I think, in lieu of tomorrow, because I think we're discussing this in more detail as an agenda item. So one was, there appears to be more information about what's happening on the ground in the assessment of alternatives than there is in the application documents themselves. So that's just the first observation. And the second is, I think we all understand the principles of Rochdale and the maximum design scenario, but there has to be a realistic scheme to assess. And I think it's the relationship between the ability of the EIA to assess the scheme and what is presented to enable us to do that. And I think it's that context within which we're speaking. So just putting that on the record in lieu of tomorrow, that it has to be a realistic and accessible scenario. And I take your point that this is outlined in context and that applications submit the maximum design scenario, but there are a lot of other projects that provide more information on their plans than we have here. So I think I'm just laying those points down in preparation for tomorrow.
Amy Sterling on behalf of the applicant. I think we would respectfully disagree. The project description for this project is incredibly detailed. It is based on Ørsted's real-world experience of delivering these projects. We have provided substantial information on the maximum design scenario and the realistic worst case for assessment, the environmental impact statement. Every chapter identifies what is the MDS for that chapter. If it varies on an impact by impact basis, we consider that our approach is robust, proportionate, but also standard across the offshore wind industry, and that where relevant and required, the maximum design scenario is secured within the draft MIC. If there are particular more helpful examples you wish us to review to see that we could adopt, we'd be happy to receive a written question on them, but we are confident that our approach is appropriate.
I understand what you're saying, and there is a lot of written description in the application and tables explaining the size of construction sites, etc. What I'm explaining is what's actually there on the plans in terms of the locations of things to present the effects. So in this application, the entire landfall site is the works. So I don't think it's something that we want to get into detail today. I'm just looking at my colleagues on the panel. I'm just laying the foundations for what we want to get into tomorrow.
Yeah.
Dr. Julian Kern on behalf of the applicant. I mean, a standard practice in the Planning Act for any DCO application that they're all the same for onshore works. Any project, I've been consenting offshore wind farms for 20 years, and every onshore works plan has been the same. That within, we just simply don't have that level of clarity at the minute. We can provide some indicative updates to what the works plans would be for each individual location. So say at Port Skilly or Groudle, we could give you an indication. So at the minute, the whole area is outlined as works 6A, B, C, D, E and F. Within that there will be compounds, there will be laydown areas, there will be access roads. That's standard. We can provide some indication of where the transition joint bay would be, where there would likely be a logistics and laydown, but that would only be indicative for just the purposes of conversation. That wouldn't be any indication of what the final design and layout of that site is going to be. I think to give you the comfort and provide you with what you would like tomorrow, it would be really helpful if we could have maybe a couple of examples of those impacts that you feel are particularly material, and then we can prepare the materials tonight so that they're there for you tomorrow. In relation to basically transparency in relation to the works plan, we have submitted the site plans at APP 183, which show the same area as the works plan, so it's just the order limits with Google Maps underlaid so that you can see residential receptors, you can see roads, you can see all other receptors. So looking at those things together that are at your disposal, it's possible to ascertain those things. So if we had some specificity in terms of what it was, we could prepare accordingly tonight, because according to the agenda item, we have prepared different information.
Thank you, Mr. Carolyn. Ms. Panel, does that complete your point? I do have further questions from my colleagues, so I'm going to bring in Mr. Smith first and then Ms. Fernandez.
Thank you very much, Ms. Sahai. I was just thinking back over, I think, an equivalent number of years, and possibly even a few more, Dr. Carolyn, of being engaged in both onshore and offshore wind consenting over a very large number of projects, and thinking about the numbers of work plans that I have seen that have at least been specific about, for example, the location of a cable corridor within a works area, the location of joint transition bays, the location of an anticipated substation site, etc. I'm thinking of East Anglia 1 North, East Anglia 2, East Anglia 3, East Anglia 1. I could go on. But if you did refer to those made development consent orders, and you actually refer to the examination libraries for those, you will see a considerably greater level of specification and detail, albeit I absolutely recognise reservations about matters that are not fully defined, where the relevant examining authorities in England accepted the importance of allowing flexibility in the scheme, but nevertheless a considerably higher level of specification than we have here. So our starting proposition, therefore, was that there is, in relative terms, an absence of detail, and I think it would be worth, before you form your view about how to respond to the line of questioning that you received from Ms. Pownall, Ms. Fernandez and Ms. Sahai, referring back to some of those made orders, because you will see the level of specification that in our experience has been normal, and therefore if there's a view that it cannot be that, there need to be some very good reasons.
Yeah. Amy Sterling on behalf of the applicant. Mr. Smith, it is perhaps more possible to be specific about the location of a substation if indeed you have a substation within your application, which of course we do not have. We do not have an onshore export cable. We do not have access roads along that export cable within our application. We are familiar with the development consent process for this client, but also members of the team for many other offshore wind projects. We are confident and comfortable that, including the East Anglia projects, the approach we have taken is comparable. I do feel we've probably gone as far as we can, other than getting different project works plans and comparing them up on the screen at the moment. It's something we're happy to take away and respond more in writing.
I hear what you say, and obviously part of the dilemma takes us back to the beginning of the conversation at the beginning of this hearing, where we were talking about essentially where you rested in terms of being able to finalise with Manx Utilities the nature of the onshore cable connection and the form of connection that you would eventually seek to make. But nevertheless, there is an observation that onshore connection points are typically the points of greatest design sensitivity in relation to offshore wind projects. They're the matters that give typically the greatest extent of concern to affected communities, and they are the locations where, quite often, to the evident concern of an applicant who is obviously concerned about the principal development and actually delivering the generating station, nevertheless, the public focus of examinations has historically been because of that interface between what you're proposing in communities. Where we need to land here, I would observe, is in a place where, even if it is in outline or indicative terms, we have a sufficient understanding of the relationship between the worst case effects assessed in the environmental statement and the specification of what is likely to be done in the works areas, so that receiving communities can understand reasonably what effects are likely to be. We can evaluate those in terms of measuring them against the policy framework. And critically also, we can get back to some of these somewhat imponderable dimensions at the moment, like, is it physically possible to make access to that place in order to bring about construction? Is it physically possible to HDD from here to here, anywhere within the site, to actually effect a practical and deliverable landfall? Because we do get back to a point of practicability here. We have to have a reasonable sense that what you propose is broadly practicable.
Yeah, Amy Sterling on behalf of the applicant. It is of course in the applicant's interest to promote a scheme which is technically deliverable. We're confident that it is. I think what might be best is if we take away an action, perhaps we can provide some sort of indicative master planning exercise of the landfall. I'm not sure that would necessarily I'm not sure that would result in an update to the works plans, because as I've mentioned, I'm not sure we will have the design to be able to further refine the works packages within the works plans, but it certainly may provide more colour, as it were, as to what might actually be happening where, and in a way that's more readily understandable and digestible.
Ms. Sterling, what I'm going to suggest is that is a good idea, but I'm going to put a pin on that. and we will return to it tomorrow. A lot of this is preparation for tomorrow. So when we cover this agenda item tomorrow, we will have a more fleshed out hearing action for you in relation to that. So we'll put it in draft in today's action list, but we will finalise it tomorrow. I do want to bring in Ms. Fernandez.
And to a large extent, none of this is new, certainly to you. And I know that you have met with DOI, for example, on just one area in relation to highways, to discuss their feedback, which is very detailed and comprehensive about the traffic and highway access. And I know that you will be working on this and have been working on this for quite a while. So I think what we're looking for tomorrow is not what you can't do, but what can you do to help us all understand some of these very valid concerns that people are raising. So understanding that much of this is an outline, but providing a level of comfort that what is possible. Whereas I think what we're looking at the moment is too vague for that level of comfort to be reached. I think that would be the way that we would ask you to approach tomorrow's preparation for the hearing.
Amy Stirling, on behalf of the applicant, we will endeavour to do so. Do you specifically want to speak about traffic tomorrow? I'm not sure. We don't have our traffic. It's not on the agenda. We didn't have our traffic expert lined up to attend.
It is on the agenda in relation to landfill construction compounds and temporary access roads. Provide details of what works have been assessed, including highways and areas in proximity to heritage and residential receptors.
Okay, yeah, I think we thought about this is what we've assessed, not necessarily the technicalities of the assessment. So Dr. Carolan was intending to cover that. We will take away your comments and see what we can do overnight.
Okay, thank you.
Now, in order to safeguard the rest of the agenda, I think I'm going to have to leave some of the sub-questions under item 4 and put them into written questions. But having said that, if anybody was holding their breath for some of these agenda items, bear in mind that agenda item 4B and C will get covered tomorrow, and agenda item F and G will largely get covered on Friday. So, and then the others will just get into written questions. And this is primarily to safeguard the rest of the agenda, which I'd still have 2 very substantive items to get through. So I'm going to swiftly move on now to agenda item 9. Right, agenda item 9 is on land assembly. And I am going to, again, in the interest of time, I'm going to combine agenda items 9A and B, possibly even C, and just pose the question to the applicant. Basically, the MIC, the draft MIC, does not include any CA powers. MEMA 26 enables an MIC to include compulsory land acquisition powers, but we know it's not a requirement. And most recently consented offshore DCOs have included land acquisition powers. And again, we note that this is not always the case. We are seeking the applicant's comments first, whether you believe land assembly as a matter is before this examining body, and your views in terms of legislation and policy on that. And then following on from that, and this is the crucial bit, is how, if at all, the examining body can rely on the benefits of the proposed development in the absence of certainty regarding land agreements.
Yes.
Ms. Sterling.
Amy Sterling on behalf of the applicant. The applicant acknowledges that there is little information on land assembly before the examining body because, as the examining body have noted, the applicant took the decision not to seek compulsory acquisition powers within MEMA. Therefore, there was not a requirement under the relevant provisions of MEMA to include information on relevant land interests. There is also no obligation in MEMA or indeed the town and country planning regime in the Isle of Man, which is similar to the UK, for the applicant for the MIC or planning permission.
Ms. Sterling, can I just focus your mind a little bit over here? We've already acknowledged that there's no obligation under MEMA for you to include compulsory acquisition power. My question to you was that how can we rely on the benefits of the scheme when that information is not before us, and that certainty indeed about land assembly is not before this examining body?
Amy Sterling on behalf of the applicant. First, I would dispute that you need certainty on delivery of the land rights. The applicant is optimistic. It is progressing land negotiations. They are going well. Land interest questionnaires have been issued to the relevant parties. Meetings have taken place. Negotiations are ongoing. The point I was getting to, that was notwithstanding, the applicant has committed to provide a land rights tracker at deadline 1, which will identify on a parcel by parcel basis the status of negotiations of the various land rights. Given that there is no requirement in MEMA and there is no requirement under town and country planning for land agreements to be in place at the point consent is granted, the examining body have to be confident there is a realistic prospect of delivery. The applicant is confident there is a realistic prospect of delivery through its own voluntary negotiations, but also the strategy in the what-if scenario, which I presume you'll get to, and I can just sort of expedite that. If the applicant is not able to obtain the onshore land rights for the Isle of Man connection voluntarily, the intention is that Manx Utilities would seek to acquire them voluntarily. Alternatively, as a last resort, Manx Utilities could utilise its compulsory acquisition powers under the Statutory Boards Act, which would enable it to use compulsory acquisition powers outside of MEMA to acquire the relevant land rights. It is intended that that would be a last resort, but it is available, and that was intended to be documented within the Statement of Common Ground, which will be submitted at deadline 1. That is for the island connection. For the AIST, which of course, as we've heard many times today, is where the majority of the power will be going. The applicant will promote a DCO, as in a standard practice when the DCO intends to seek compulsory acquisition powers. Nevertheless, as a business, our strategy is to acquire the land rights it needs voluntarily, and it has been very successful in doing that and in not obtaining, not having to rely on compulsory acquisition powers to deliver its projects. And as the examining body helpfully noted, there are many examples of many offshore wind schemes that have been delivered without any compulsory acquisition powers at all. So they are not a prerequisite to the grant of planning permission, indeed neither are the land rights.
Can I invite Manx Utilities to comment on this point? Would you like to come to the table? I will bring in Department of Infrastructure as well.
Stephen McGee, Interconnectors Manager for Manx Utilities. A colleague of mine, as I mentioned earlier, was to join me today, so he would have answered this question directly, but I'm happy to give an overview of where our powers lie in relation to this question. If there are any follow-on questions, I may have to refer them back to him and come back with a written response at a later date. So, statutory powers, Manx Utilities statutory powers in relation to land rights are very limited in the context of the Mooir Vannin infrastructure consent. For the project as currently proposed, the cable assets up to the transition joint bay would be owned and installed by the applicant. Manx Utilities do not have any statutory powers to acquire wayleaves or easements on behalf of the applicant, and we have no involvement in securing land rights for those assets. However, if in the future a joint venture model were pursued in which Manx Utilities becomes the owner of the cable infrastructure associated with the potential island link, then this position would be different. Manx Utilities does have powers to acquire wayleaves only where it is necessary for MU to install and maintain its own electric lines. These powers would apply only if MU were legally responsible for the cable, including its long-term operation and maintenance. However, these powers would still be subject to a compulsory wayleave application process managed by the DOI. To be clear, that is not the position under the MIC application, and no such powers are being relied upon in the project currently before the examining body. Any future consideration of a joint venture approach would need to be subject to its own governance, commercial evaluation and consenting process.
Thank you. I think we will probably have follow-up questions, but bear with me, I do have a certain chain of thought. So first of all, just in terms of timing, clearly, whether you enter into a joint venture agreement or whether Manx Utilities will need to do anything under their, compulsory acquisition powers, that's not going to come before this examining body. Okay. Now, in that regard, I think that still leaves the point which you have disagreed with us already, whether the certainty about or a certain comfort about deliverability of the project, whether or not that is before the examining body. And I think, sorry, you want to say something on that point, Ms.
Amy Sterling, on behalf of the applicant. I don't disagree that there's no information on land assembly before the examining body. I do agree that there is a lack of information, and we've agreed that we will provide that for deadline 1. The statement I disagree with is that you need certainty on the land delivery at the point of making a recommendation, or indeed the Council of Ministers granting consent. I disagree as a point of law.
But I think the point is not as a point of law, it is more about us having an understanding of the benefits or the deliverability of the benefits of the scheme in order to be able to, simply do the planning balance exercise.
Amy Sterling, on behalf of the applicant, that is noted. I think it goes back to the discussion we had this morning that the primary benefit of this scheme and the needs case for this scheme is to deliver the government policy for its economic benefit from delivering an offshore wind farm in the territorial waters to export to the UK. So, at the risk of repeating what we said this morning, that the connection to the island is just but one, I don't want to use a small part of the overall planning balance, and the case for the scheme is not reliant on the connection to the island, and therefore is not reliant on the availability of the land rights at landfall.
Okay, I am going to bring in Ms. Fernandez, who has a question, but before I do that, you did mention that you are submitting a land rights tracker. Let's just talk about that maybe at the end of this agenda item, because I do want to know exactly how you're structuring that. And I'd probably like to have some input into what information we'd like to see. For instance, from the representation that we've just heard from Manx Utilities, it is not immediately clear to me whether the route of acquisition for every parcel of land is going to be exactly the same. It seems that it might be varied. And so I would like to understand what that route is going to be. Whether or not it's before this examination, I think is... it is not that important. What I think in terms of the information that I'd like to see is how that would be negotiated and what comfort we can give to the Council of Ministers on that. Ms. Fernandez.
I sort of do hesitate to ask this question of the applicant, but nonetheless I'll ask it, and perhaps you might want to consider what the answer is before giving it. But there is a part of our thinking is, why are you applying for an export cable to the Isle of Man and landfall and all the associated stuff that's required to connect the project to a substation on the Isle of Man if the primary purpose of the scheme is to export? So I'll probably just leave that question there. But the related question is, do the provisions of the draft MIC, in your opinion, compel you to provide work number 6 and others onshore activities or the export cable from the array area to the landfall area? Does the MIC compel you to deliver that?
Amy Sterling, on behalf of the applicant, no, the MIC does not compel us to deliver that.
A much more modest question then, which is simply matters of possible legal detail in terms of understanding the potential implementation routes that are being considered by Manx Utilities, and acutely conscious of the fact that what may be being contemplated in terms of a joint venture is not part of the material that's currently before this examination, but it really would assist, I think, to be clear about the legislation currently enabling the formal acquisition of way leaves by Manx Utilities, as in which act, which sections, which provisions of it, and also whether that extends to enable acquisition of land or rights more broadly than just way leaves. In other words, in circumstances where something more substantial were to be required, can it be?
Okay. If I can take, sorry, Stephen McGee, Interconnectors Manager for Manx Utilities. If we can take that away as an action and do a written response for you, that would be helpful. Thank you.
Actually, that was almost the basis of the question that I asked, where I said that I do want to have input on the land rights tracker and the form it takes. Because that is exactly the point I'm trying to get at. So presumably you're going to have the same thing. What is the parcel? Who's got the ownership? What type of ownership? And what kind of rights you want on it? And what is the route to procure, to acquire that? And that was the very basis of the question, is that it's possible that there some acquisition might be much more substantial than way leaves and easements, and how you would get to that. So, Ms. Sterling, I know you're eager to come in.
Amy Sterling, on behalf of the applicant, we will provide all of this in writing. To confirm, Schedule 2 of the Statutory Boards Act 1987 provides that the board, being Manx Utilities, may acquire land, and elsewhere in that it confirms that includes rights in land compulsorily for the purpose of any of its functions. So, to repeat, the board may acquire land compulsorily for the purpose of any of its function. That is a broad provision. It is subject to ultimate approval of the Department of Infrastructure in the normal way, as if a compulsory purchase order was promoted, but we can provide a more detailed analysis in our submissions, and of course, as I've mentioned, we are engaged with Manx Utilities on a regular basis, and this will be covered in the statement of common ground between the parties. The applicant's primary intention is to acquire all land rights voluntarily. It is proceeding on that basis. As I mentioned, land interest questionnaires have been issued and meetings have taken place, negotiations are progressing. In terms of the applicant's strategy, again, we will provide more detail in the land interest tracker. I can provide highlights now, as it were. What the applicant would intend to do, as it has done on its other many schemes that it has brought into operation, is in the first instance seek initial option for easement agreements, which would identify an area of land in which the applicant would intend to install infrastructure. It would then carry out detailed design and then take forward more refined option for easements over the land that it intends to carry out construction. It would then intend to carry out construction works, and then post-construction would exercise the option for easement so that the easement was acquired over only the permanent infrastructure. That is the approach it has taken on its schemes to date. The benefit of that is that it reduces the burden on the landowner, because the easement is taken over the refined as constructed corridor rather than the construction working with, as it were. We can cover that in more detail. In terms of the format of the land and rights tracker, I have a draft in front of me, which I will just sort of explain. If there's anything in particular you would like to see, please do tell me, or are happy to receive in writing. we have assigned what is essentially a plot number, which I'm sure you'll be familiar with, with reference to a plan to particular land parcels. We're identifying the land interest. The thing that we're currently reviewing is whether or not we can provide the personal information of the landowner, because they are not currently participating in the process, even though they are able to. There's also no legal requirement for us to provide this. So under the Data Protection Act, we're not entirely comfortable at this moment that we can provide the personal details of those landowners. But we then do, we ascribe them sort of landowner A, landowner B, landowner C. That's how we've done it at the moment. We identify the type of interest that they have in the land. We then provide an update on the status of negotiations with that land interest on a bullet by bullet basis, whether we've got responses to the land interest questionnaire, when the last meeting was, when the next meeting's intended. And then we also have a column of the likelihood of resolution prior to the end of examination. So the intention is this would be a working document that we'd update on a regular basis through examination.
Ms. Sterling, thank you, but I think we're going to need more on that. So bear with me while I just process some of that and give you some a bit more headings to populate potentially underneath that. Sorry, I just have to ask this question. Why did you not give us this in response to the Reg 31 letter?
Amy Sterling, on behalf of the applicant, we didn't think it was necessary, but in preparing for this hearing, we realised it would be helpful for the examining body.
Okay. Right, I am going to bring in now a Department of Infrastructure. And I know I'm jumping around a little bit, but there is method in my madness here. What I'm going to do is cover off agenda item 10B. So any comments from the Department of Infrastructure, and in particular, if agenda item 10B you'd like to cover off in your response at this point, that'd be good.
Mr. Garden, for the Department of Infrastructure, thank you for that. And in terms of the previous item that was discussed, I think no additional comments in relation to the compulsory purchase. I think we referenced this morning that we would consider at deadline 1 the potential linkage between the current works and future consent onshore, and this is probably a similar matter that we'll consider there, but otherwise no comments from the department. In terms of item 10B, I think there were a few items that were raised earlier that we just wanted to talk through. The first is effectively the approach to the timeline for discharge of requirements as we move forward, and that's something that we have raised in the consultation response. That's PCR 171, where we have raised the concerns around a relatively short time frame being imposed in the draft MIC of 6 weeks for determination of applications to discharge requirements. I think we've kind of seen today that there's a significant effort that needs to be expended in bringing forward updated draft outline plans, and I think the concern is there's a significant amount of plans that will need to be submitted at the discharge stage that will cover a detailed amount ranging from underwater noise through to kind of onshore construction, etc. So a lot of information that needs to be submitted to the department and for the department to consider. It's also worth touching, I think, in relation to that on the non-determination piece, and there is at the moment the ability for an appeal process, but what is also in the draft MIC, Regulation 2.3 in Schedule 4, in the appeals process is effectively a deemed approval process if there's not a response to the requirement within that 6 weeks time frame, and that is not acceptable to the Department of Infrastructure and not something that can be agreed to.
Thank you, Mr. Garden. Just in terms of the 6 weeks period for the discharge of requirements, I mean, I will bring in the applicant, but do you want to say what your concern is with that with respect to some of the other made DCOs, and what time scale you're expecting in regard to that precedence? Yeah,
absolutely. So, Mr. Garden, for the Department of Infrastructure, I think the applicant's justification for this is based primarily on the appeals process that is put in place for onshore requirements in DCOs. And it's worth noting that a lot of the requirements, indeed those in Part 2 of the relevant schedule, relate to significant marine matters that under an English DCO would ordinarily be dealt with through a deemed marine licence and dealt with by a discharge of condition through the Marine Management Organisation, the MMO. I mean, in DCOs to date, the MMO is given a significant amount more time, and the Hornsey DCO, the Hornsey 4 DCO promoted by the applicant, has a 6-month time frame for approval of a number of these management plans that we're talking about, things like scour management plans or cable specification plans. And that is more the time frame that we would be looking for, given the significant amounts of plans that will need to be approved by the department. It's also worth noting that there's not an appeal process in relation to conditions under the deemed marine licence. Again, it's ordinarily for discharges pursuant to onshore matters that are dealt with through the relevant planning authority in English and Welsh DCOs. And that probably then leads on to a final point in relation to the appeals process that is currently set out in the draft MIC, and particularly the paragraph 4.2 of Schedule 4, where there is reference to the application of the Town and Country Planning Development Procedure Order 2019, which is effectively a terrestrial piece of legislation, but the draft MIC seeks to apply that to any appeals process, and with the words, with such amendments as are reasonably necessary to make the appeals procedure applicable to this. And from the department's perspective, that appeals process is also unclear. And I think if there is to be an appeals process in relation to the discharge of any requirements, then what we would expect to see is something that is more specific and bespoke and probably reflects what you see, again, in some of the other DCOs that we see onshore. And again, I would point to the Hornsey 4 DCO, which does have a set appeals process contained within it.
Thank you, Mr. Garden. So do you want to take both these points in turn? First of all, the discharge of requirement time period and whether that can be accommodated, and the appeals process and what your response is to that.
Amy Sterling on behalf of the applicant. Yes, the applicant is aware of the DOI's concerns. We are actively engaged with them. I don't have instructions on a specific timescale at the moment, but it is something we're keen to discuss. We are seeking to set up a call amongst ourselves, essentially, as soon as we can after these hearings. I think, apology, that was me, I hit my pen on the mic. As soon as possible after these hearings, to discuss this matter, to balance the Department of Infrastructure's concerns from the applicant's wish to proceed with the development in a timely manner. So I'm confident that a suitable compromise position can be reached soon in examination. In terms of the appeals process itself, I mean, again, deemed discharge will also be part of that conversation. I don't think it would be fair to suggest that the applicant should be deprived of any appeals process. That would not align with any planning process. The purpose of us including the reference to town and country planning regime was because it was an existing appeals process with the Isle of Man that the DOI would be familiar with. Therefore, we thought it would be beneficial, rather than creating a whole new process under the MIC, to rely on the existing process. We take Mr Garden's point that there's a lack of specificity perhaps on the relevant sections within those appeal process and any amendments that are required to make it work for the MIC, and that's something that we can certainly, again, working with the DOI to provide. So in summary, points all noted, subject to discussion, confident they're resolvable.
Good summary. Thank you. Okay, I'm going to move on very quickly, and I'm just doing a quick scan through my agenda. We've covered off 9A, B, C. D is ever so slightly redundant now. Okay. Written questions? Let's cover off agenda item 9D then, and then I will come to 10A after that. Okay, let's cover off agenda item 10D, and the point here, it's exactly as written. Just talk us through the relevance of the Scottish examples that you've referred to in your submission PDR-006 and the relevance with reference to Crown Estate arrangements and established market norms that may be different to those in the Isle of Man.
Amy Sterling on behalf of the applicant. The intention to reference the Scottish examples was essentially just to demonstrate my point, although I appreciate there was a lack of detail, that it is not necessary for a compulsory purchase order to be promoted for an offshore wind farm and its connection to be delivered. The reason I reference Scottish examples is because these are recent large-scale offshore wind projects which proceed to consent multiple gigawatts without any promotion of a compulsory acquisition order. I have a list before me. The more recent projects within England proceed through the DCO process, therefore it's become custom to sort of wash your order limits with compulsory acquisition powers. However, even in England, pre-DCO, wind projects proceeded through the Electricity Act and were consented via Section 36 in the Town and Country Planning. It was not routine to also promote an Electricity Act compulsory purchase order. That was the sole intention, essentially, of the reference. It was for points of alignment, as it were, rather than difference.
Any follow-ups? Okay. Okay, thank you for that, Ms. Sterling. I'm just looking around the room if there are follow-up questions. Doesn't look like any hands up. So I will move on to agenda item 10A. The reason I'm moving on to agenda item 10A is because I believe this morning there was a representative from Douglas City Council and whether you wanted to make any representation as a possible landowner.
Dana Einan on behalf of Douglas City Council. We hadn't registered to speak, and as I alluded to earlier, during the preliminary meeting yesterday, it became clear that the applicant is looking to withdraw Portskillion as landfall, and that's where our interest is. We have already submitted our LAES. I appreciate the deadline is 31st of March, but we've already submitted it. And our only reference in that document is to the fact that to date there have been no discussions with the council over the use of the land, and if Portskillion was to be used, we would expect there to be quite detailed discussions and negotiations.
So it's just worth highlighting one a matter of process, that while the applicant has submitted a change request, the change request has not been accepted, and there is a certain process. So until the change request is in fact submitted, if it is submitted into examination, Portskillion is still a part of the order limit. So you will see earlier in agenda item 4, I made sure that they were talking to the previous plans rather than what they were proposing our post-change request. So I would encourage you to continue engaging on the basis that Portskillion is still in. And in that regard, if you had any representation to make in terms of how your land and rights are affected at this hearing, then I would welcome that.
Dana Eyre on behalf of Douglas City Council. Yes, we are intending to stay engaged. Noted your comment from this morning. We don't currently have any representations at this point, but we are intending to attend tomorrow when some of these items will be discussed in more detail.
Okay, good. And just again, bearing in mind that land and rights are ever so slightly distinct from, the effects of a particular proposed development in environmental and spatial terms, do engage on both sets of matters. Okay. As when I did the roll call this morning, I don't think there was anybody present whose land and rights were affected other than that. So I'm not going to make a submission. But yeah, I don't see any hands up either online or in the room. Ms. Sterling, you're eager to come in.
Amy Sterling on behalf of the applicant. Yes, this discussion reminded me I hadn't been at all clear that when I was referring to land interest questionnaires having been issued and discussions progressing, that was at the Groudle landfall zone only. We are not currently progressing voluntary land rights at Portskillion because we do not intend to take forward that landfall zone, even if consented. So we are not seeking voluntary land rights. I realised I wasn't clear on that.
Okay.
And I just wanted, for complete transparency, to correct the record as
But
well.
presumably that is still included in your land and rights tracker.
Amy Sterling on behalf of the applicant. We can certainly include mapping. There wouldn't be much detail of negotiations because we're not negotiating.
But potentially no negotiation, but potentially an explanation why there is no negotiation, so that it's all out in the public domain and before the examining body.
Amy Sterling on behalf of the applicant. We can certainly include an explanation.
Fine, good. Okay, so for now, Ms. Sterling, as I've explained to everyone, that until the change request is formally accepted into examination, just assume, for all submissions, it really should be based on the order limits that's currently in the application documents. Okay, I'm just going to bring in Ms. Fernandez.
Yes, may I just track back on that in relation to our role as an examining body? So we have the application in front of us, and at the moment that includes Portskillion and Groudle Bay, the landfall zones. Regardless of our decision, we do need to report on the application in front of us. So it may be premature just to, in your mind, stop Portskillion, because, as we say, we have not made any decision in respect of that change request. You may find yourself in a position where you may not have enough time to do some of the work that enables the whole application to be considered. So I would just ask you to reflect on your strategy on that point.
Amy Sterling on behalf of the applicant. The position is noted, but the applicant has taken a business decision not to progress with Portskillion. Therefore, it would not be proper for us to seek to enter option agreements with landowners, potentially restricting their use of land under those option agreements where we do not intend to take forward that landfall zone. What we have put forward is a reduction in the extent of development we are seeking. Whether or not the examining body accept that is, of course, a matter that you are considering. It is not, almost regardless of that decision in the MIC, practically a landfall zone that we intend to take forward.
That's understood, Ms. Sterling, but I think the point that Ms. Fernandez is making on behalf of the panel is that we still need to interrogate the whole scheme. So until the point that the change request is, but we note your point that, even if you were to get to the examination, change request not accepted, and if consent is granted, you will just not proceed with that component. That point is understood. Okay, I'm going to move on now. I think the agenda item 10C, safeguards if negotiations with landowners or other parties fail. You have partly covered that, but bear this question in mind as we get on to agenda item 10D, which is primarily on procedural fairness for affected landowners. And I am going to expand this ever so slightly. I have referenced only Article 6 of the European Convention on Human Rights, but I am going to expand this slightly when I put this question to you. So we just need to consider the issue of procedural fairness for affected landowners and occupiers in light of Article 6 and 8 of the European Convention on Human Rights and Article 1 of the First Protocol. So just for avoidance of doubt, Article 6 requires that where civil rights are affected, individuals have access to fair and transparent process. Article 8 provides in light of respect of private and family life and is applicable where dwellings or their settings are potentially affected. Article 1 of the First Protocol for the peaceful enjoyment of possessions and that persons are broadly not to be subject to unjustified or onerous expropriation. So in many infrastructure regimes, regimes. This is addressed this is addressed through compulsory acquisition powers, which include statutory procedures and compensation rights. And in this case, that position appears different, as the land and rights required onshore are understood to be secured solely through voluntary negotiation. And we're looking for your approach on this, that how is procedural fairness basically, if negotiations don't proceed as planned, how are people regarded those rights?
Amy Sterling on behalf of the applicant. I think it's fair to say that if the marine infrastructure consent is granted, that will have no bearing on the land rights position. The applicant is not taking land or rights through the marine infrastructure consent. The applicant wouldn't have any land rights as a result of the MIC, and no one would be deprived of land rights as a result of the MIC. In terms of notifications, ability to participate in hearings, the applicant is complying with MEMA and its regulations. There are no particular provisions in there which require engagement with landowners where compulsory acquisition powers are not being sought. Site notices have been erected in accordance with the legislative requirements, but nevertheless there has of course been public consultation, and indeed this hearing is being held. Landowners do have the ability to participate in the process, but in our submission these provisions are not applicable because the applicant is not depriving anyone of their rights. And as I mentioned previously, there is no requirement in MEMA for the applicant to be the landowner. It is open to anyone to promote a marine infrastructure consent, and they comply with the requirements of MEMA in terms of notification and engagement of the relevant parties. That's predominantly through site notices under MEMA. So the question, the applicant has been procedurally fair. It has complied with the letter of the law that it is required to do. It's also complied with the spirit. We're here, we're having this hearing. I'm not, so our submission is that we are, procedurally fair, I guess.
Ms. Sterling, I'm going to hand over to Mr. Smith for some questions.
All of those points, Ms. Sterling, clear and noted. But there is an interesting question of temporality here, because over a slightly more extended period of time, there is at least a contemplation of there being a backstop acquisition process. Is that correct?
Amy Sterling on behalf of the applicant. Possibly. I'm not sure I agree. I know what point you're making. I'm not sure I agree.
Can I put a for instance to you then? If the consent were to be granted and you were to be in a position where you did wish to implement an onshore cable corridor and you therefore did need to obtain access to land onshore in order to start to construct elements of that corridor as provided for in what would then be the made order, and an individual who benefited from land or rights within that red line boundary were to happen at that point to turn around and say, no, not interested in concluding negotiations, what would you do?
Yeah, Amy Sterling on behalf of the applicant, we would seek to continue. It's not unusual, I would say, for people to say no at first pass. We would continue to negotiate with them. We would work with Max Utilities to continue to negotiate with them. As I have mentioned, the absolute last resort, which is subject to its own statutory regime, may be the arrangement, a JV arrangement that Max Utilities referenced, and Max Utilities potentially using its compulsory purchase powers, which is subject to a different statutory regime. Or ultimately, the island link wouldn't be delivered. That's the ultimate backstop.
Yeah, but nevertheless, there is a backstop. It's a Y-forks backstop, with one side of the fork being non-delivery and the other side of the fork being engagement with some contractual arrangement or joint venture or separate statutory mechanism with a partner that delivers you to something that amounts to a compulsory acquisition mechanism.
Amy Sterling on behalf of the applicant. No, I don't agree, sir. If we're talking about sort of an analogous situation in the UK, the mere existence of compulsory acquisition powers within a statute does not create an injurious affection of land, if that's where we're heading. If someone is granted a planning permission for the laying of a cable, the very fact that it may at some point or be able to at some point in the future promote a compulsory purchase power under the Electricity Act, for example, does not result in an injurious affection of land.
Indeed, no, it doesn't. But there is a mechanism within that backstop framework that enables the person, the affected person, I'll use the Planning Act of 2008 terminology, enables the affected person's interests to be brought before a decision maker, before what in that case a compulsory purchase order or the compulsory granting of way leave would be made.
Amy Sterling on behalf of the applicant. And a person is only an affected person for the purposes of the Planning Act if you're seeking compulsory purchase powers over their land. We don't have any affected persons in this application, so I'm not sure I follow the analogy.
The point that I'm trying to make to you is that if you were successful in terms of receiving a grant of consent, it appears that in order to be able to implement the proposal, either you or an entity forming a joint venture, or alternatively a third party, would need to be able to enter onto land and would need to be able to physically construct works, and some of those works appear at least likely to be things that would need to remain on land, and so would at least in principle require the transfer to the beneficiary of those works of a substantial right over that land, if not an enduring ownership.
Amy Sterling on behalf of the applicant. The scope of the permanent works is an underground cable and a transition joint bay, so that would be an easement.
Transition joint bay would be an easement?
Yes.
Mr. Smith, I think let's see the land rights tracker, because one of the things that I'm going to request the land rights tracker to include is things like the equivalent of a statement of reasons. So not the full statement, but usually the table that's appended to the statement, where you've got exactly what you need each plot of land for. And so if the joint transition bays are just going to be an easement, we'll just need to understand how that works, what kind of rights you've got. I mean, it is for you to determine, you know, what kind of rights you need over things, and for us to be able to interrogate that. But
to take on board that, I mean, that there are instances where such things do require surface works and do require ongoing accessibility, for example. I'm going to just cycle around a little. If we're looking at a backstop mechanism that might be the Statutory Boards Act of 87 that's been referred to, if an acquisition of a way leave or easement or right or indeed land were to be pursued under that mechanism, is a person whose land or rights is being sought, does a person have an opportunity to object? Is there a provision made for their objection to be considered in writing or by a hearing process? And is there an independent adjudication taken by a person other than the beneficiary of the final decision? That might be a Manx Utilities question. I would.
Thank you. Stephen McGee, Interconnections Manager for Manx Utilities. As previously mentioned, if a arrangement was in place where we became an owner of the cable in question, then any application to apply our statutory powers would follow a process, which there is a managed process for that, and what we can do is detail where that fairness aspects come out of that process to the actual the landowner and their rights in that process, if we can do a written response to that after the meeting.
That would be very, very helpful indeed. Now, What I would like to do before I return to Ms Sterling on this point is just check in with the other departments, particularly DOI. And I do see we have an online request.
Thank you, Mr. Garden, for the Department of Infrastructure. I think Ms Sterling referenced it earlier, but in terms of the compulsory purchase process, the DOI does have the ultimate sign-off on that. So any compulsory purchase in the future would go through the department, and so would be subject to that approval. And I think it's probably also worth noting that there's, whilst the regulations are due to come in, there is also a potential change process to a MIC as with the DCO, which could potentially extend to compulsory acquisition. But beyond that, I think the department has no other comments on this, sir. Thank you.
Thank you very much. Now, I think I do need to take that just finally back to the applicant. Yes, just having deliberated on that a little more, before I do go back to the applicant, if I can return to the DOI and indeed Banks Utilities, that final approval process, again, noting that at deadline 1 we're going to receive something in writing that frames what it is, if it's coming from the DOI as an entity that owns a final approval process, again, we need to be clear about the particular statutory provision under which it proceeds, the degree to which there is a process that entails the obtaining of the views of the person whose land or rights are affected, and then the degree to which that is placed before a person who may make some form of independent recommendation prior to the final decision, or alternatively that there is no such provision. Mm-hmm. You know, it's just a factual statement of what administratively and statutorily is there in order to bring such a process to its termination, so that we understand where it rests. Is that something that between you, Banks Utilities and DOI, you will coordinate by deadline 1 and be able to respond on?
Yes, Steve McGee, Interconnect Manager, Banks Utilities. Yes, we can certainly take that away and give our opinion of an answer to that fantastic question.
Just to clarify, I think what the point we've got to is potentially a joint statement from Manx Utilities and DOI about the process that would need to be followed should negotiations fail in order to compulsorily acquire land that is required for the proposed development, and for various scenarios. So whether it is to what extent you need what type of rights. Yep. Okay.
Okay. I think that's
done. Can I just change your mind now away from that particular conversation, but to track back to Port Skillion, which is still playing around the back of my head. And it's something that was in APP 042, Table 4, and that talks about the in-out status of Groudle Bay, and Groudle Bay was removed at one point during the pre-application process because of the excessive length, and I'm quoting, the excessive length of the terrestrial export cable corridor if a landfall was made at Groudle Bay. And so my question to Manx Utilities is there a technical limitation to how far an onshore corridor would or could be? And then to the applicant to explain, given their view that of the excessive length, why they have gone back to Groudle Bay. So firstly, Manx Utilities, please.
Stephen McGee, Interconnector Manager for Manx Utilities. First part of that question is no, the terrestrial onshore cable from where we have now got to with connection points, there is no limitation or constraint in relation to the extent of the length of that terrestrial land cable. In relation to where we got to with Portskillion and Groudle Bay, the preference for Groudle Bay was reached following a joint evaluation by ourselves and the applicant. The work considered operational resilience, route diversity and protection of the existing interconnector infrastructure, constructability, available landfall working room, and also environmental sensitivity and long-term adaptability. Groudle Bay scored strongly across all these categories, particularly in avoiding conflict with our existing offshore and onshore assets and enabling a more future-proof cable route inland. By contrast, the Portskillion presented higher risks for existing infrastructure, including constrained emergency access and limited space for future expansion. On that basis, we concluded that Groudle Bay represented the most technically and operational robust landfall option for the island link that we're currently considering.
Thank you. And if I may turn to the applicant as well, please.
Dr. Julian Carr on behalf of the applicant. Just in relation to the text that you quoted, so discussions with Manx Utilities in the post-scoping stage led to the applicant deciding to prioritise landfall at Douglas Promenade due to the indication from Manx Utilities to make grid connection at Lord Street. This was due to the excessive length of the terrestrial export cable corridor required if landfall was made at Groudle, and that is specifically in relation to a grid connection being at Lord Street. So the grid connection offer at that point, we had looked at some feasibility with Manx Utilities, and we had an early indication of putting in a grid connection feasibility request or something similar, Steve can clarify, for 40 megawatts at Lord Street to see what the capacity was and what the electrical infrastructure required would be. And if that was possible at Lord Street, then we could build up from the 40 megawatts up to the target 100 megawatts. And at that point, because Lord Street was the preferred option and Groudle wasn't the preferred landfall location, because I don't know if you know where Lord Street substation is, yeah. So it was Portskillion or Douglas Promenade would have been the preferred location. But because the grid connection location has now upgraded to a larger capacity, it's Pulrose and Portskillion, so that consideration now is no longer valid. Does that make sense?
Yes, thank you. And I do understand. I do know where Lord Street is and Pulrose. But the difference between Pulrose and Lord Street isn't far in geographic terms.
No. It's not far in geographic terms, but it's quite complex to get to Lord Street from Groudle, because you would have to come around, all around Douglas and back around and in. While it looked a feasible option to make a HDD from close to Douglas Promenade and come up onto the promenade and work our way through to Lord Street, that looked like a feasible connection option. And at 40 megawatts, that would have been one cable. So it's something that it wasn't beyond the realms of technical feasibility, but two cables in the Lord Street would be significantly challenging.
If I may, Amy saying on behalf of the applicant, I think it's also important to note that the text that we're all quoting here is a record of the applicant's position as explained during an evidence plan process which took place in Q4 2023 and Q1 2024. It was as at a point in time rather than the applicant's position now. It's a record of engagement rather than the applicant's current position.
Yes, indeed, but nonetheless, excessive length wouldn't change. The length would be the same whether it was then or now. Hence my question is whether that was a technical limitation or some other reason. And I think between, yes, Manx Utilities.
Stephen McGee, Interconnector Manager for Manx Utilities. Just to follow on to the point made by the applicant in relation to the length, it was also capacity. So when we moved from potentially 40 megawatt up to potentially 100 megawatt, the connection point really needed to move away from Lord Street due to over resilience on critical infrastructure in that area. So that's where we looked for a diverse connection at Pulrose, which could accommodate up to that capacity.
Thank you. That's helpful. Thank you.
Thank you.
Okay, thank you. So here's my plan to keep to time. I am going to put a few follow-up questions to agenda item D. Let me just quickly double check 10D in written questions. I am also going to put agenda item 11 in written questions. And I'm just looking to see if the departments or any other parties have an issue with that. I don't see any hands up, so I'm swiftly moving on. Sorry, Mr. Garden.
Mr. Garden, on behalf of the Department of Infrastructure. No objection to that, but one specific comment that we did want to make, and hopefully will come through in the questions, relates to the need to consider monitoring and remedial measures in terms of drafting and enforceability. So I appreciate that may be part of your written questions, and if so, nothing to say on it today.
I am looking at my colleagues here, but it's possible that some of this is being covered tomorrow as well.
Some of it's being covered. We can look at tomorrow.
Yeah. But yeah, Mr. Garden, that is being covered in written questions.
Thank you.
Okay. And then the plan is to cover funding and deliverability information until about 5 minutes past 4. And then we will be roughly 20 minutes late, running late on our agenda, which is not so bad given where we were after lunch. So, moving on to agenda item 12. It's about the funding and deliverability information that is before the examining body for this application. And again, I'm going back to the point about the extent to which the project would benefit the Isle of Man from a net zero energy security perspective. And these are the policy elements which are advanced in support of the project in the application's, in the applicant's planning support statement. If the proposed development cannot actually deliver those benefits because of financing arrangement, then it seems that this becomes a planning matter. You know, the deliverability, the funding available to in fact deliver the project. And so I want to ask the applicant whether that information on those grounds can be made available to the examining body.
Amy Sterling on behalf of the applicant. A clarification, if I may, the planning support statement does not rely on helping the Isle of Man achieve net zero for its planning case. It specifically says that it won't be able to help Isle of Man achieve net zero, certainly by the 2030 target, given the timescales of the development. It does make the case that it could be an additional source of resilience to the power supply. We're providing an updated planning support statement. The primary case, as I've said, is that the applicant will export electricity to the UK and provide an economic benefit to the Isle of Man through the agreement for lease in accordance with government policy. So the applicant's case of development is not underpinned by the provision of the island link. We've obviously covered that on several occasions now. The applicant is confident it has the ability to finance and fund the delivery of the proposed development and indeed the whole project. The applicant is preparing a funding statement to demonstrate its ability, its financial standing and ability to deliver the whole project. This will include all elements, including the Isle of Man connection and the East Irish Sea transmission project, so that the panel, the examining body, can be satisfied that there's no sort of material impediment to the scheme proceeding. I can provide more information on the specific figures if that would be helpful now, or we can defer to the funding statement that will be submitted at deadline 1.
I think it would be difficult to make sense of figures without context, so it would be helpful to see that set out quite clearly before us. Given that you're preparing a funding statement, it is worth also highlighting that the implementation, the extent to which we want that deliverability assurance is very much from the point of view also of mitigation. So, to the extent to which the requirements can in fact be implemented and therefore provide that appropriately controlled, therefore the adverse effects of the project are appropriately controlled. So when you're providing, because I don't have anything in front of me, it's just worth setting out what we need to be able to assess from the funding statement so that it is comprehensive enough when it comes before us.
Amy Sterling on behalf of the applicant. Yes, the cost of all these mitigations are included within the funding model for the scheme. It's the construction of the offshore wind farm is by far the most expensive part of the process, but nevertheless the applicant will see what detail it can provide within the funding statement on perhaps a range of costs that the mitigation measures might cost and how those are accounted for within the funding model.
Fine. Any questions? There's nothing further from the examining body, so I'm just going to turn to the room to see if there's any questions from parties present. Mr. Strafford.
Thank you very much. Ian Strafford, Isle of Man resident. Can I, just for point of clarity really, it's not a question. I think what I have just heard is a statement from the applicant that one of the previously key proposed benefits to the Isle of Man in terms of contribution to net zero, climate change and clean energy for the Isle of Man is now being withdrawn from their proposal in terms of the benefits that have been previously highlighted for this project. Can I just clarify I've heard that correctly?
Mr. Strafford, thank you. Ms. Sterling, that deserves a response. Thank you.
Amy Sterling on behalf of the applicant. There is no proposal to withdraw the Isle of Man connection from the application. The point I was simply making, which was raised by members of the public last night, is that the Isle of Man has its own strategy and timescales for delivering net zero that are not dependent on the proposed development. That many members of the public have made that clear. Nevertheless, and that is reflected in the applicant's planning support statement, nevertheless, the applicant's project is providing an important opportunity to build resilience into the system from a renewable source. And of course, a climate change act commitment to achieving net zero is not the same as achieving net zero. And so when any of the pathways that the Isle of Man are currently on to achieve net zero not to come forward within the timescales required, the project would be available to fill the gap, as it were. It's not the case that the Island Link is being withdrawn. It's simply a matter of timing, given the relevant targets for 2030 and the timescales from this project in the late 2030s.
It would actually be really helpful to get some confirmation from government departments on that point, that the island's net zero targets, and of course, quite simply, signpost to the energy strategy would just be helpful. But the island's net zero strategy does not rely on the Vannin offshore wind farm to achieve that target.
Ken Milne here from DEFA. There's probably two parts to that, if I may. The first part's the net zero part, so there are two targets in there for climate change.
Okay.
There's the decarbonisation of the power sector by 2030, and then there's net zero emissions by 2050.
Okay.
So although this project is not scheduled to be part of the decarbonisation of the power sector, there will still be all the other parts, the heating, the transport, in the future will need to be decarbonised. So it could play a part of that. And then the second point is about energy strategy. We will be providing those documents as part of Deadline 1 as requested. But in there, it's about resilience, it's about independence for the island, for its power infrastructure, and this could play a part in that as well.
Okay. Mr. Strafford, does that answer your question?
Yeah, thank you. Ian Strafford, Isle of Man resident. I would say partly. And I would say partly because I recognise the 2030 target and that it can't play a part in the 2030 target because of dates. I recognise the 2050 net zero aspect, but in order for it to play a part in the net zero aspect, that would require a connection to the Isle of Man, I believe. Otherwise, if it was exporting solely to the UK, we could take no credit for the carbon offset that the UK is taking credit for. So without that connection, it isn't possible for us to use it to offset as part of net zero for 2050. And I think that's the clarity I'm trying to seek, and hence the importance of the connection to the island. And if that does not see, and that, at the moment that would seem to be a benefit that's in doubt, maybe, from what I've heard. And therefore it's important to keep bearing that in mind from my perspective, in the sense of the claims that are being made and what has been, I will, in my language, as a receiver of it, I will say has been sold to the population of the Isle of Man of the benefit of this project.
Okay.
Thank you.
Ms. Sterling, would you like to come back on that?
Yeah, Amy Sterling on behalf of the applicant. I mean, we entirely agree with DEFA here. We certainly can provide an option for resilience to the system and an option for achieving net zero. All of this information is contained within the planning support statement. I would encourage everyone to engage with the planning support statement. We are updating it for deadline 1. It is also important to note that a lot of the power to the Isle of Man comes from an interconnector between the Isle of Man and the GB grid. So decarbonisation of the GB grid, for example, through the East Irish Sea Transmission Project, would indeed decarbonise the Isle of Man electricity system, because the electricity comes through the interconnector regardless of the delivery of the island link.
Mr. Strafford, thank you for that, Ms. Sterling. Mr. Strafford, there are some pending questions in my mind as well, so we will pursue this in written questions. Anything further from my colleagues? We will take a quick break otherwise. Okay, is that all right? Okay. The time now is 1 minute past 4. We'll take a break for 20 minutes actually. We do want to sort of actions. Let's come back at 20 minutes past 4. Okay, welcome back everyone. Did we lose some light in the room? Is everyone okay on this side? Light? Yeah? Is it the same? Okay, good. Time is 4:22 p.m. and I am resuming session 4 of SIH 1. Before we get into the final agenda item for today, what I want to do really quickly is just run through the actions, applicant, you might have listed so far, just to be able to compare them with what I have got. And then I'll turn to the departments to see what you've got and just corroborate my list.
Amy Sterling on behalf of the applicant. The person noting the actions isn't sitting at the table, so I'll just have to do a bit of a shuffle to take their laptop to sort of. Thank you. Yeah. Do you want me to run, or do you want to run down? Yeah, okay. Sorry.
Dr. Julian Kearn on behalf of the applicant. These are the actions that we have. Confirm that the whole project figure shown in the project description is updated and the substation colour is correct. Action 2, draft and submit a programme for the deliverability of the terrestrial transmission assets with justification for its current status, with remaining technical aspects to be determined between the applicant and AMU, Manx Utilities. 3, to update the Statement of Common Ground with DEFA and DOI to include policy support for offshore wind farm with export to a neighbouring jurisdiction. 4, to update outline plans to include mitigation measures in order to mitigate significant effects. To provide a programme for the development of the outline plans.
Dr. Carolan, can I just pause you there for 1 second?
Yes.
The video is not on our screen. You sure Teams is up and running? Okay, I was missing that screen. Okay, sorry, carry on.
Where was I?
You had just finished with the Statement of Common Ground from DEFA and you were on the one after that.
Yeah, to update outline plans to include mitigation measures in order to mitigate likely significant effects. To provide a programme for the development of the outline plans alongside the examination timetable. DOI to provide the examining body with consultation materials on marine infrastructure post-consent regulations 2026. To include approach to update a draft MIC in relation to the marine infrastructure post-consent regulations, non-material changes and safety zones in the Statement of Common Ground with DOI. To provide draft legislation, post-consenting regulations to the applicant and the examining body. To draft figures showing indicative layout of landfall works at Groudle Bay. To draft updated works plans showing increased transparency of works areas to view geographical features beneath them. To review updated works plans at Groudle Bay showing refined works areas not yet submitted. To include the route of acquisition for each parcel of land within the land rights tracker and to submit a table of amended, or to submit table appended to Statement of Reasons.
Amy Sterling on behalf of the applicant. Those are the notes that we currently have before us. We do also have other people online who are taking notes of actions. So it's not been a reviewed or perhaps comprehensive list. So if you have others, and I'm not sure actually, I would appreciate as a point of clarification if you will be releasing the examining body's action points following the hearing. That's sometimes done in a DCO
Do you mind
process.
if I cover that at the end of the hearing? But I will cover that.
Yes, no problem.
Okay. Just a very quick one. The actions that I've got missing are the ones that are for tomorrow. So the actions that we've given you for tomorrow in terms of presenting the information that we've requested.
Which actions?
Amy Sterling on behalf of the applicant. I think that's covered by to draft updated works plans showing increased transparency of works areas to view geographical features beneath them. I think that was one of the requests that we currently have GIS working on for tomorrow. And there was another one in here, so I'm sort of on the hoof now trying to read across screens. about draft figures showing indicative layout of the landfall works at Growdall Bay and sort of to walk through those. That's two actions that we had for tomorrow.
Yeah, okay, fine. Can I just turn to departments? Is there anything missing from that list that was there for you, which... Mr. Milne?
Ken Milne for DEFA. I think we had one additional one. It was the list of discrepancies we identified in the MIC and the EIA.
Yeah, and that was for before deadline 1, so as soon as possible, so that the applicant can actually respond to it at deadline 1. And then there was the action for Manx Utilities. Would you like to come forward?
Stephen McGee, Manx Utilities. The three actions I took away as a note was an indicative programme for the onshore infrastructure that sits outside the MIC. Second one was outlined our statutory powers and the associated procedures for fairness. And third one was to work on a joint statement with the DOI and Manx Utilities for the compulsory powers.
Actual statement to a statutory powers. Should negotiations. Yes, and for various scenarios. So it was not... Yeah. Mr. Garden, I'm just wondering if there was anything pending with you. There is.
Mr. Garden for the Department of Infrastructure. No, the only additional action I was going to mention was the joint statement that Manx Utilities have just referred to. So nothing further.
There was the one about the legislation, the two bits of legislation that are coming forward, one with respect to the safety zone and one with the appeal, basically to affect the two provisions in the MIC, and then what the draft provisions, or indeed the removal of the provisions, would look like in the draft MIC.
Yeah, Mr. Garden for the Department of Infrastructure. Yes, happy to pick that up, and I know the applicant has referred to that as well, so we'll work with them on that.
You're right.
Yeah, thank you.
Okay. I believe there was an action for Mrs. Trafford. You had referred to some national policies which you felt that the applicant had omitted to include, and you were going to submit that for deadline 1.
Yes, Ian Strafford. I will endeavour to find papers in relation to both the Climate Change Act, but also the landscape character assessment documents, and the commitments within there to protect the seascapes, etc., as part of key fundamental aspects for the Isle of Man.
Okay, and once you've submitted that, Mr. Strafford, we will seek corroboration from government departments and their commentary on it. But it'll be good for the examining body to understand what it is that you are referring to specifically.
And I appreciate that, and I'm sure if there's other government documents out there that I'm not aware of, that the government departments would be able to find them. Thank you.
Which they are under instruction to do anyway. So, okay. Okay, so that's really good. We've got this list, and we will just return back to this at the end of the hearing, when I will issue a procedural direction with respect to hearing actions and next steps. I've already asked it, so yeah. Okay, moving on to agenda item, the final agenda, and that's on protective provisions. And I just want to say that for the people who've been here all day for this agenda item, we're very grateful. So this is agenda item 13, and well, it's absence of protective provisions for third parties. We've highlighted this, and indeed other parties have as well. So we are seeking justification on basically the applicant's response to Berber Extension Limited, Scottish Power Renewables, and Orsted Schroeder's Green Court. And basically, the justification we are seeking is the absence of protective provisions from your draft MIC. And this is with respect to policy 1C of the Isle of Man Strategic Plan 2016, which states that development should make the best use of resources by being located so as to utilize existing and planned infrastructure, facilities and services. Basically, some sort of cooperation with existing utilities and infrastructure, and indeed with regard to national policy statements for energy infrastructure, and I've listed specific paragraph numbers. So at the examining body, it's just unusual for protective provisions for an application like this to not include protective provisions. And in response to, consultation response, you have said that you do not consider them to be necessary to be included, and we're just seeking some understanding of how you intend to approach some of those interfaces with existing utilities and infrastructures.
Amy Sterling, on behalf of the applicant, I think we can distinguish existing utilities and infrastructure within the order limits from the parties you mentioned, the Barbow extension and essentially to west of Duddon Sands companies. Those are existing operational assets distant from the order limits. The applicant has committed at the preliminary meeting to update the draft marine infrastructure consent to include protective provisions which will benefit the beneficiaries of utilities within the order limits. For example, submarine telecoms cables. Those protective provisions will be in a form which has become standard across development consent order processes, with any relevant amendments that have to be required for MEMA purposes. For example, the sharing of plan of works in advance, taking on board any reasonable requirements when working in the vicinity of those assets. The applicant will submit those within the next iteration of the MIC, which I believe the examining body has scheduled for deadline 2. The situation with Barbow extension and west of Duddon Sands is distinct from that. Those are, as I said, existing operational wind farms some distance from the order limits, and the applicant has not identified any reason, any impact from the proposed development that would have to be protected by way of protective provisions. And indeed, protective provisions for the benefit of existing offshore wind farms is not common practice within development consent order process. I have a more detailed sort of synopsis, as it were, of the concerns that have been raised by these parties and the applicant's position on those. I can provide you those now if helpful.
Ms. Sterling, that's fine. I think what I want to do is actually hear from the parties first and then come to you. So if I could just open the floor. So what I have is, I believe that's Mr. Gregg first, followed by so I'm struggling to see a name with the person who's raised their hand first. It is SPR Wads. Would you like to turn on your microphone and your camera and introduce yourself? I think this introductions. Yeah. So we're unable to hear anything. We're unable to see your picture as well.
Amy Sterling on behalf of the applicant. From my notes, it was an Anthony McNamee.
Yes. Yeah. So somebody's just entered. If this doesn't work in the next couple of seconds, then we'll just move on to Mr. Gregg. Mr. McNamee, are you... there you are.
Yes, sorry, apologies, we're having some IT issues, so apologies for taking your time on that. I just wanted to briefly interject and make 2 brief points. So I'm acting for Scottish Power Renewables in their capacity as a 50% shareholder in the west of Duddon Sands offshore wind farm. And I just wanted to pick up 2 points made by the applicant. One about the lack of protective provisions being needed and there being no impact on the west of Duddon Sands wind farm. I'll call it WADS for short. I think in the applicant's most recent submission, they've confirmed that there is an impact on the WADS project. And so we think that that obviously should be mitigated. The second point is in relation to policy 1C and the best use of available resources. We obviously look forward to working with the applicant on protective provisions to ensure that any wind power generated from the applicant's project obviously doesn't come at the expense of existing generation being supplied to the UK, given that the applicant has clarified that the primary purpose of the project is to supply the UK with new electricity. And that's all. Thank you.
Ms. Sterling, would you like to come back on that?
Amy Sterling on behalf of the applicant. I take then yes from Mr. McNamee's submission that he's suggesting protective provisions for weight loss. Our position is we've submitted our weight loss assessments and we will be providing an update at deadline 1 as to what that weight loss assessment shows and why that is compatible with the obligation and policy to mitigate wake. I would refer to paragraph 2.8.233 of MPS EN3, National Policy Statement EN3, which is a UK document, but one of the policy documents that the Examining Authority has referenced, which says there is no expectation that wake effects will be wholly removed between developments or that compensation arrangements are a necessary means to mitigate the impact of wake effects. And developers may opt to take such approaches outside of the planning process. The parties are engaged with each other. Discussions are being set up to discuss these wake loss assessments. There is no planning precedent for protective provisions in relation to wake loss, and the applicant does not propose protective provisions for wake loss within this application.
Mr. McNamee, did you have a response on that?
No, we are working with the applicant separately and look forward to productive discussions. But as I said, I think in this instance, protective provisions are needed. And as the applicant pointed out earlier on in the process, the extensive policy work that the Isle of Man has done to get to the stage that they're at now obviously wouldn't have been brought forward with the intention of reducing existing supplies to the UK. Thank you.
That's helpful. I'm just, so it's good to know that you're speaking to each other, but there will come a time in the examination if matters are not resolved and agreed, then the matters would potentially need to come before us. So at what point do you think that potentially some kind of protective provisions would need to be being negotiated?
Amy Sterling on behalf of the applicant. The policy framework that we operate in, if we're borrowing from UK policy, given there is no policy around weight loss, as far as I'm aware in the Isle of Man, doesn't require protective provisions. It does require consideration of how weight loss might be mitigated. We'll be making those submissions early in examination at deadline 1 as to how we have mitigated weight loss and complied with policy and what those weight loss assessment shows. The so what of that, as it were, will be undertaken outside of the planning process, which is again compliant with policy. As I referenced, NPS EM3 is explicit that developers may opt to take those discussions outside of the planning process, and the compensation or other arrangements that may be in place between operational and proposed wind farms, we would suggest is not a matter that concerns the examining body. If there's any suggestion of a reduction in power that may affect the planning balance, then again we'll address that as early as possible at deadline 1. But purely commercial arrangements between the parties we propose should remain between the parties. There is no intention to put forward protective provisions.
Mr. McNamee, are you satisfied with that?
I look forward to working with Ms. Sterling over the course of the next few weeks and take on board the points she's made.
Are you entering into a statement common ground with each other?
Amy Stelling on behalf of the applicant. Yes, we're progressing a draft statement of common ground for deadline 1.
Okay. Just a very quick one before I forget this. You said the draft marine infrastructure consent with the protective provisions is being submitted at deadline 2. I think the updated MIC is being requested at deadline 1 in the timetable.
No, deadline 2.
Is it deadline 2?
Deadline 2.
But I think we wanted a deadline 1.
Amy Sterling on behalf of the applicant. The draft timetable says deadline 2. We're more than happy to provide it at deadline 1. Deadline 1 would be more usual. Obviously, the final timetable I think will be published soon after
as
this
soon
hearing.
as practicable. What we will do is that we'll put that in the hearing actions. We will remember to do it in the final timetable as well. But yeah, we'll expect that at deadline 1. I will hand over to Mr. Smith for a.
Just in terms of making sure that we cover off everything that we need to in relation to submissions around the degree to which wake effects are relevant and security anywhere within the face of an order might be relevant, I just wanted to throw onto the table the following: the Mooir Offshore Wind Farm Order 2023 Requirement 25, the Mona Offshore Wind Farm Order 2025 Requirement 29, and the Morecambe Offshore Wind Farm Generation Assets Order 2025 Requirement 13, which in their own ways do, of course, address the point at issue, notwithstanding that those are requirements and not protective provisions. But there's a degree to which some made orders have grappled with this. Now, I'm very conscious of the fact that there's then been a policy shift, but what would be very, very useful would be to see the applicants and indeed any other offshore wind farm beneficiary stroke operator who considers that formal provision for wake effect loss might be relevant, to see their submissions on A, the treatment of that issue in made order requirements, and B, then to refer to the latest version of the MPS Energy Suite and cap off the question of whether we should still be doing it that way.
Amy Sterling on behalf of the applicant. Yes, we're familiar with the references you've quoted. There are also other references of recently made development consent orders where the Secretary of State has chosen not to impose a wake loss requirement. So there is essentially recent precedent both ways. Our position is such a requirement is not required for this project. We do intend to provide further commentary on wake loss at deadline 1, and we will address that point, sir.
Thank you. Yes, I think if we are seeking a balanced set of submissions around this, then if you are equally relying on other made orders that have not included those provisions, then let's have those referred to as well.
With emphasis on ones where Secretary of State has indeed expressly removed a requirement of that nature.
Amy Sterling on behalf of the applicant. Yes, we will provide references to precedent both ways. Ultimately, I think, as I said, this is a point that the applicant is actively discussing with the relevant parties. A call has been scheduled even for next week. So we're hoping substantial progress between us can be made in the short term, and we will, of course, keep the examining body updated. Meantime, we will do as you've requested.
Thank you, Ms. Sterling. Can I request Mr. Gregg Hello, Mr. Gregg. Can't hear. Mr. Gregg, your microphone's off.
Sorry about that. Sorry, Michael Gregg, DLA Piper, on behalf of Burwood Extension, the Wolney wind farms, and also for Ørsted Schroders Greencoat in relation to West Dublin Sands. Some of what I was going to say has already been covered. Just again, one point is that the representations here again are not just in relation to Burbo and Wads, but also in relation to the Wolney wind farms, which is particularly important because they're the ones that are closest to the proposed development here. The other point, I hear what Ms. Sterling says, and again, similarly look forward to discussing things further. I'm not clear at the moment what it is that the applicant is proposing to do, if anything, by virtue of addressing weight loss impacts. But again, we'll have discussions with them which hopefully will be productive. In relation to weight loss and mechanisms for addressing those within DCOs, I note the references to the made DCOs which have been referred to. I was similarly going to make the same point. I think I was making a couple of additional points in that as well. And that my understanding is that the decision on Morecambe post-dated the most recent changes to the NPS on renewables in relation to weight loss, which I think is quite significant because it seems to give the Secretary of State's view on what appropriate weight loss requirements may be, and they will obviously vary depending on the circumstances. But in that revised policy world, so I think that's of significance. The other point I was going to make in relation to those, again picking up on something Ms Stirling said, is that the protective provisions on hourly more did not just cover weight loss, but also cover other impacts on potentially affected wind farms, which might be affected by construction impacts as well as weight loss. And the submissions on behalf of my clients don't just relate to weight loss. They also relate to other potential impacts on the developments, but from the developers' operations, particularly in relation to the cable works. Because again, the difficulty with this project is that it's, and this has been discussed at length throughout the day, is it's part of a wider project, and the cable connection works to the UK will start in Isle of Man waters, continue then under a different regime into English waters, but there are the works will take place in quite close proximity to my clients' developments, and there are obviously concerns there about how that may impact on the existing operation of the wind farms, as well as the ability to carry out any necessary maintenance, and how we coordinate vessel movements, etc. So from our perspective, it's important to ensure that these works are properly coordinated, both for the works in English waters, and obviously acknowledge that that's a separate process, and no doubt we'll have this discussion elsewhere, but also in relation to the linked works in Isle of Man waters, because these presumably will need to be coordinated properly. So there's that aspect as well. It's just to make the point that it's not just weight loss; it's also other impacts on the operation of the existing wind farms.
Thank you, Mr. Gregg. And just in terms of where negotiations are with the applicant, how confident are you that you are at least going towards resolution on some of these matters?
I think they're probably at an early stage at the moment, Madam. I would hope that, I mean, certainly the indications we've had have been quite productive in terms of the discussions we've had, but they are early days. So it's difficult to know at the moment if they would be productive or not. So I guess there is the possibility that certainly our hope would be that we'd reach agreement with them in relation to how these various matters might be addressed and what the mechanism might be, because obviously there's various ways in which this could be done. But obviously, if that's not the case, then we would have to reserve our position to put forward appropriate protective provisions. And as I say, I think there are precedents for this in relation to offshore wind farm impacts, not just in relation to weight loss.
Mr. Gregg, I think maybe not a deadline one, but I think at a suitable deadline, let negotiations proceed as they are right now. I am going to ask some questions to the applicant, but at some point it will become pertinent for you to potentially submit your draft version of protective provisions into examination. And let me come back to you on when that appropriate moment might be. But I suspect deadline 1 might be too soon. But I will just ask the applicant a few questions. One of the things is what Mr. Gregg said is that he's not very sure what the applicant is planning to do about weight loss effects. And I just wondered if you might put some colour on that and, you know, just explain to us where negotiations are headed.
Amy Sterling, on behalf of the applicant's position is that the matter of weight loss, certainly in terms of any sort of commercial negotiations between the parties, is outside the planning process. So for the purposes of the MIC application, the applicant isn't intending to do anything. It's not intending to submit a draft requirement. It's not intending to provide protective provisions. Also, without wanting to sort of trade precedents, Mr. Gregg mentioned the Morecambe decision being granted after the MPS updates. After the Morecambe decision, the 5 Estuaries decision was released, and where the Secretary of State refused to impose a requirement or indeed any protective provisions for weight loss. There is precedent both ways. We will address those at deadline 1. As I've mentioned, we do have a call with Mr. Gregg's clients being arranged for next week. The applicant intends to discuss these commercially. They're commercially sensitive, and I'm not in a position to share the topics of that discussion with you, I'm afraid.
One of the points that Mr. Gregg has made is that it's not just about that, it is wider effects as well. And unless I've misheard him, he has given the example of a Wellamore, the Welsh project. Did he not make reference to that? Mr. Gregg, did you? He did. Yeah. Did I pick that up correctly, Mr. Gregg? Did you refer to a Wellamore offshore wind farm?
Yes, Michael Gregg for Wolney, Burbo and Wards. Yes, that's correct. I did refer to Wellamore.
So with that reference, Ms. Sterling, I think it would be helpful to just understand what your approach is in terms of the more wider construction effects and operation effects.
Amy Sterling, on behalf of the applicant, certainly I can turn to that in just a second. The Awelli and Mooir decision was the first to impose a requirement in relation to weight loss. So I understood Mr. Gregg's submission in referring to Awelli Mooir was only in the context of weight loss. I'm not sure if he can be given the opportunity to confirm, or if there was something else in the Awelli Mooir decision that he felt was relevant to this examination. I didn't understand that.
Mr. Gregg, do you want to come back on that real quick?
Yes, Michael Gregg for Burbo, Wolney and Wards. As I thought I could confirm to you, Madam, the point was not just in relation to weight loss. There are protective provisions in the Awelli Mooir decision which give protective, which have protective provisions for the benefit of both Rill Flats and North Hoyle in relation to construction and operational impacts on the existing wind farms. Those are over and above the provisions and the requirement in the Awelli Mooir DCO, which deals with weight loss.
Presumably you've understood that point, Mrs. Sterling. I just want to bring in Mr. Smith on a few clarification questions.
We've landed in a place where we have an in-principle submission from yourself, Ms. Sterling, that there is no need for any provision, that you will do nothing. There are alternative views around the table in the examination that either requirements and or protective provisions and or commercial agreements may be relevant. And it was on that final point of commercial agreements also that I just wanted to make a touch point, because if I think back to days as early as the consenting process for the Burbo Bank extension offshore wind farm, there an approach was taken uncontentiously around the table in that examination that there were certain matters that would be provided for by commercial agreements, and they were, and the parties were very willing to come back to the examination and say not what the content of the commercial agreements was, because those clearly were commercial in confidence, but they were prepared to to agree in public that they had agreed, and that therefore an issue that they had agreed was a matter that the examining authority could at least place some weight upon in terms of it no longer being a matter of dispute or of relevance to a public interest decision. Now, I guess the reason I raise that is because looking at the various optionalities that there are here around where this might land, that being prepared to at least refer to commercial processes to that degree could actually be very productive.
Amy Sterling on behalf of the applicant. Yes, the applicant is progressing a statement of common ground with each of these parties, and no doubt this will be a topic covered. If I may return to the other non-weight loss impacts that have been referred to, as far as I'm aware, no evidence or specificity of what those impacts are have been provided into examination. The consultation responses refer to work number 4, which is the export cables within the proposed development, which before the exit into the UK exclusive economic zone, the applicant has carried out an EIA and has not identified any likely significant effects on those existing operational wind farms. If the interested parties are suggesting that there is an impact, I would suggest it for them to specify what that impact is and provide some detail of that impact that we can engage with. That doesn't seem to be before the examination at the moment. What they do say is the concern essentially seems to be around the East Irish Sea transmission project and what may come down the line. That would not be an appropriate protective provision for this consent, and indeed wouldn't fall within the scope of MEMA, that sort of cross-conditioning, as it were. Article 37.2 of MEMA provides that a marine infrastructure consent may impose requirements only in connection with controlled marine activities or associated marine activities for which consent is granted. The East Irish Sea Transmission Project is not the subject of this consent application. I would suggest it wouldn't be competent for protective provisions, or indeed necessary for protective provisions to control the EIST development to be included within this consent. And an examining body, in accordance with the Gateshead principles that you referred to, can take comfort that the Secretary of State, when determining the DCO application, will impose the relevant regulatory requirements at that time.
That point is well made, Ms. Sterling, but I think the point that Mr. Gregg made, Mr. Gregg made, is that while some of those effects might, or those interactions might be in the East Irish Sea Transmission Project, there will be some coordination required when the project is still in the Isle of Man and Manx waters, basically. So he wanted those matters covered by protective provisions under this examination. So I just, you know, and if I have misunderstood that point, either made by Mr. Gregg or Mr. McNamee, then do come in. But that was my understanding of why these but your point that there's nothing specific in terms of adverse effects is well made, and I am going to invite both Mr. Gregg and Mr. McNamee to respond to that very quickly, because I think this is potentially a hearing action which we would expect a fuller response at deadline 1. Mr. Gregg, you've got your hand up.
Thank you, Madam Michael Gregg, on behalf of Burble Wolney and Wards again. What your summary of the position is correct. That I accept that, and I said that earlier, that the impacts or potential impacts in relation to the existing wind farms are primarily related to the works which will be authorised by the separate DCO in the East Irish Sea. The issue here is really related to that aspect of the cable connection works, which is within Isle of Man waters, and the need to coordinate the installation works there with the installation works in the East Irish Sea, where there will be the potential for significant impacts associated with that, because they're in very close proximity to the existing wind farms. And indeed, as I understand it, one of the routes goes through part of the existing Walney wind farms. So it's about coordination of the projects. I suspect probably the best way to take this forward, again, we're going to have discussions between the parties, and probably the best way to deal with this is to have the discussion, see the extent to which we can come to agreement, and hopefully we will. And it's only then, if we have an issue, that we need to consider then about a backup for proposing alternative protective provisions or not having protective provisions. Hopefully what we would have is a situation where we both come back to the examining board and say that the position has been agreed.
Nonetheless, I think just to safeguard that position not being reached within this examination, there's two actions potentially. One is that it would be helpful for us to understand more specifically what the adverse effects are, in particular for Walney wind farm, and if you can give us a bit more detail about that at deadline 1. And then there's a wider action that is for all parties seeking protective provisions from the applicant. Should matters not be resolved, we would expect early draft protective provisions from those parties at deadline 2, so that the applicant can consider them, respond to them, and if we do get to close to the end of the examination and matters are still at an impasse, then we have a draft wording in front of us. Okay. Anything further? Okay. So I think that covers off. Applicant, did you have anything further? Okay. I think that covers off deadline agenda item 13, and we can move on to I feel Is there anything further? And I'm going to come to the parties on this first, Mr. Gregg and Mr. McNamee, unless there are other parties, Manx Utilities perhaps, if they want to make a point here. On agenda item 14, which is basically the reliance on post-consent negotiations, which was the applicant's position, but of course it has ever so slightly moved on from that. Is there anything on this matter that you wish to raise, even if it is as a potential risk?
Stephen McGee, Manx Utilities. I think our position at the moment is we recognise that many of the details that we require to obviously finalise our design, and obviously any ongoing commercial discussions can only be finalised once the project moves into a more detailed design, and we are comfortable working through this, working through those details post-consent.
I suppose that just leads me to agenda item 14B, which is what are the safeguards if negotiations with you fail on some of those matters?
Steve McGee, Manx Utilities. I think the provisions we've got around our discussions to date around design, around potentially some future commercial agreements, and the work we're currently undertaking on a statement of common ground is heading to a position where we've got some confidence that if this project is taken forward, we can get to a reasonable agreement where we can realise the benefits the project can offer the island.
But actually, what would be helpful for the examining body to understand is that in terms of the assets that are affected, so a lot of those commercial agreements also get secured through protective provisions. And we're just keen to understand that if you're unable to take some of those negotiations to, successful resolution post-consent, what's your fallback option?
Sorry, Stephen McGee, Manx Utilities. The proposals we've had from the applicant to date does give us a number of options, whether they form into a fallback option, because there's always going to be a break point where the offer on the table just does not make sense for us at a commercial level.
Okay. I can't say I'm 100% satisfied with what you've told us, so we will probably pursue this with further written questions. Applicant, did you have any points to make here?
Amy Sterling on behalf of the applicant. I guess just to clarify that the utilities which are located within the order limits are not Manx utilities. For example, there's a BT telecoms cable within the order limits. It would be, for example, BT who would benefit from those protective provisions. Okay. Okay, thank you, Ms. Sterling. I'm going to just hand over to Ms. Fernandez for a follow-up question before I come to the parties on Teams.
Mr. McGee, just for my own understanding, what you say relate to commercial considerations, in headline terms, what would be the sort of considerations that you would be contemplating to see whether an agreement could be reached with the applicant? What, in an understanding that you don't need to get into the detail, but what would be the main areas you'd be thinking about?
Steve McGee, Manx Utilities. The context I was coming from really with my response there was for the overall island link. So that was the viability of the island link as a project for Manx Utilities to realise the potential benefits it could offer the island.
That feels a little bit like shorthand. Can you just say a little bit more about that?
Yeah. So sorry, Steve McGee, Manx Utilities. As previously mentioned, there's obviously a number of options for the island link, and one of them would be some form of joint venture. So in that joint venture would be a set of heads of terms around an agreement around ownership, obviously capital investment, ongoing operational costs, etc.
Thank you.
Thank you, Ms. Fernandez. I've got Mr. McNamee first and then Mr. Gregg. No, the other way around, sorry. Mr. Gregg first and then Mr. McNamee.
Michael Gregg on behalf of Burbo Wolney and Orsted Schroders Greencoat Woods. Just in relation to the question on relying on post-consent negotiations, I think the position is that we don't think that would be satisfactory from our perspective. Obviously, the preferred position is to reach an agreed settlement with the applicant in relation to the points we've put forward, failing which we would be proposing protected provisions, and it's been indicated that should that be the case, then we should do so at deadline 2.
Okay. I will come to you, Ms. Sterling, but I just want to get comments from Mr. McNamee first.
Thank you. Just to confirm that I agree with Mr. Gregg's position, actually, that endorsing everything he said, that protected provisions would be preferred, but obviously we're entering into discussions with the applicant directly.
Thank you for confirming that for us. Ms. Sterling, did you have any follow-up points?
Amy Sterling on behalf of the applicant. Nothing more further to say. I think we've made our position pretty clear.
Okay, good. So I think the main actions emerging for the applicant here were well, the updated draft MIC at deadline 1, and then there was a action for Mr. Gregg about further detail on the operation and construction effects, particularly for Walney Wind Farm, that will be affected. And then ultimately for draft protective provision wording to be submitted at deadline 2 from both Mr. McNamee and indeed from all parties who wish for that to be a consideration in case negotiations fail. Okay, I'm going to just move on now to agenda item 15. And we are seeking detailed information on this matter through written questions from the applicant. But it would help us greatly to understand if you could give us an overview of just identifying utility providers, and you have already named a few, but utility providers and statutory undertakers whose assets might be affected by the proposed development, whether or not they have submitted a consultation response, and whose assets would ordinarily be protected by protective provisions under the DCO regime.
Amy Sterling on behalf of the applicant. The details, including a tabulated summary of who owns which asset, are included within the examination within the offshore crossing schedule, that's APP 069, and the onshore crossing schedule, APP 070. In preparing for this hearing, I think there may have been omission potentially of one cable onshore that we will rectify for deadline 1. We can ask the Cabinet Office to pull those up now if helpful, otherwise they're before the examination and we'll be submitting updates at deadline 1. It provides details of the relevant assets, and at the back of each of those schedules a list of the asset owners.
If it is an update, Ms. Sterling, I think we'll stick with deadline 1. But yeah, that's helpful signpost. Okay, let me leave it at that. I think what we will do is that then proceed with the following 2 questions in written questions. I think that would be most suitable. Good. Where that leaves us, do any parties have any comments to make on agenda item 15? Okay, good. Where that leaves us is to just consider our actions briefly. Okay, I'm going to propose that given the applicant, Manx Utilities and colleagues from DEFRA and Department of Infrastructure and Mr. Strafford have all listed the various actions, which has corresponded to our list as well. And there were 3 further actions emerging from this agenda point. Can I assume that actions emerging from this hearing at this point are understood by all parties? Yes? Okay, that's excellent. Now, I think where that leaves us is for me to just make a final procedural direction in regard to hearing actions emerging from all hearings this week. And the approach the examining body is taking is that because the approach the examining body is taking is that all actions will be included within written questions. And we will identify where these are actions emerging at hearings by saying further to the hearing action from SIH1, but responses to all of them will be at deadline 1. I think besides one single action for DEFRA, which was ahead of deadline 1, everything else, my recollection, is at deadline 1. Except for the draft protective provisions. So we will include them all in written questions. So there will not be a second issuance from the examining body with hearing actions. Is that understood by all parties? Yep. Okay. I think all that remains is for me to close this hearing, but I just want to look around and see if anybody had any final comments. There's some frantic discussion on my right, and I'm wondering if anybody needs to come in before we close.
Yes, Ian Brooks from the Department of Infrastructure. Just want to seek some clarification.
Go on.
In terms of information that's being requested as part of the action points. Are we still including anything relating to Port Skillion, or is it just going to...
Absolutely. Until we make until the examining body accepts the change request into the examination, if it does, the assumption is that the application is as submitted. Is that understood? Okay, good. Okay, I think, but any clarification from you, Ms. Sterling? No? No. Okay, good. So we are 12 minutes ahead of schedule. The time now is 18 minutes past 5, and I'm now closing specific issue hearing 1.